ಅಲ್ಲೇ ಫುಲ್ List to continuous ಕರೀತೀರಾ? List to continuous ಕರೀತೀರಾ? ಅಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್
Your Lordship, kind permission, man.
Preliminary hearing.
One matter for tomorrow, my lord. The matter is not settled before the mediation center. It was referred by this honorable court. They are not appeared before them. Kindly have it. Well, because of the urgency, there is no means for the to maintain herself and also the child. Or any day, any.
Execution fee provided by the trial court, my lord. Petition is wife husband, my lord. Suppress in fact, trial court is already trial court local law settle the matter. Suppress in the fact the maintenance started in 2025, my lord. 7/4/25, my lord. Next week.
ಅಲ್ಲಿ ಲೋಯರ್ ಕೋರ್ಟಲ್ಲಿ MEC 4 ಲಕ್ಷ ಅವಾರ್ಡ್ ಆಗಿತ್ತು, 1.5 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿ ವೆಹಿಕಲ್ ಆಫ್ ದ ಓನರ್ ಸ್ಟೇ ಮಾಡಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದು 2015 ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ. ಲೋಯರ್ ಕೋರ್ಟಲ್ಲಿ MEC. ಅಮೌಂಟ್. ಥ್ಯಾಂಕ್ ಯು.
So respondent wife is trying to trouble me because of previous orders. Respondent's wife is trying to trouble my lord. Respondent wife is trying to trouble my lord by using the previous orders and urgency. Husband is facing problems.
MFA matter, my lord. The respondent counsel has filed the application for interim award.
This is MFA matter, MVC, so a date may be. Family court matter, my lord. Maintenance. Next week, any date, red petition.
My lord. Adjournment. Serial number 83, adjournment.
Lordship, item number 84, Lordship, the previous other side counsel has been informed by the on-record counsel, Lordship.
What about this, list number 2, mediation matter, list number 2, mediation matter, all are referred to mediation, all the matters, 8, 6, 8, to the Bangalore mediation center. Yes, all 8, 5. Adjournment, list number 1, page number 7, 29, 30, page number 8, 31 to 34.
32 minutes. The petitioner counsel instructed to state that it has become settled between the parties.
Page number 9, page number 35 to 37, page number 10.
Serial number 36, please, Lord. Appear for petitioner. 36. 36, my lord. Appear for petitioner. Statement of objection today are filed in the registry, Lord. Matter may be taken up any day in.
Non-compliance about statement of petitions to obey. Filed by registry. Because like other side comes, what is there to file in there?
Please, Lord.
Page number 10, page number 38 to 44, page number 11, 45 to 53.
45, my lord. For petitioner. Kindly adjourn the matter for 7/8, my lord. Because my senior is not well and some inconvenience, so.
The senior's absence will be granted.
Wait. Interim order ಕೊಡ್ತಾರಂತೆ wait ಮಾಡಿ ಅಂತ. Wait ಮಾಡಿ.
My lords, serial number 51. Lords, I'm withdrawing the petition has become infectious, my lords. Judgment has been passed. Yes, other day matter. On the same day, the judge has passed in favor of us only, they have passed that. Yes, my lords. Principal court. Yes, my lords. Please.
For the matter being adjourned. Either 1 week or 2 weeks, whatever. No, not
And you want, there should be a reason for adjournment, and then you want, that you can tell the court.
The reason is this, the matter is likely to be settled if my party, husband gets some crores of rupees by selling a particular property, which is the brothers.
This is matter on 13th of no further adjournment.
13th. Please.
Page number 13, serial number 61 to 57.
Not serial number 62 minutes for respondent notes. Kindly have it on Monday. Today, some inconvenience for today. Please. No, Monday we will not seek any adjournment. It may be recorded as finally minutes.
Lord, serial number 67, I appear for the respondent. I seek for 2 weeks' time. There is personal, I've also informed the other side, there is personal inconvenience from a senior to attend the matter, some personal emergency. So 2 weeks' time may be granted. Grateful, Your Lordship.
Serial number 65. I'm 65. I'm appearing for the petitioner husband. I filed NOC Wakalat on 18th of July. My name is not reflecting, Your Lordship. The matter came up on 23rd of July. There was an interim order granted. Since my name was not reflected, I did not appear on that date and the interim order wasn't extended. I've informed the other side. For the petitioner, I filed my NOC Wakalat on 18th of July, Your Lordship. For the petitioner husband in the main matter, Your Lordship. Inderjeet Yadav.
Page number 14.
75, 75. But the matter between the parties are mediating. The other side have also no objection to adjourn by 2 weeks on the ground that the matter is likely to settle. It's already under the mediation. Yes. Very well. But interim order subsisting may be continued. Yes. Please.
Page number 15, serial number 85.
83. This settlement is going on. I have informed the respondent. I am for petitioner. Kindly have to do it. Settlement going on.
Whenever the matter comes to court, then only the settlement will
No,
happen.
no,
That's the problem.
no, no. Yesterday only we had discussed with the advocate and.
This can't also 13, same ground, no further adjournment.
My lord, serial number 80, my lord. I appear for respondent, serial number 80. Senior is not feeling well, my lord. 1 week time, other side is informed, my lord. Other side inform ಮಾಡಿದೆ. Inform ಮಾಡಿದೆ.
He says he has already informed.
Inform.
Lordship, item number 84 of 84, Lordship. Item number 84, Lordship. I am proxy to the on-record counsel, Lordship. He has instructed to me. He having some personal inconvenience, Lordship, and he's already been informed to the other side counsel, Lordship. It maybe have it next week, Lordship.
Why counsel like inconvenience today only, tomorrow?
No, Lordship. What I am proxy to him, Lordship, and what he is given. Any date may be kindly fixed for the next week, Lordship. He will be appear before the court, Lordship. Apologies, Lordship. May I know what?
May I make one request, my lords? I'm sorry, I'm in serial number 7, parted matter. Lords may kindly recollect, I was asked to, my lords, produce the document to show I have paid the future educational expense. I have received the documents today morning. I could not go through that. My lords may post this matter either tomorrow or day after tomorrow. I'll place it. My lords, 7, my lords. Tomorrow or day after tomorrow, my lords. Great, great.
My lords, a
My
small
lords, kindly,
submission.
I'm sorry, my lord, list number 2, serial number 22, my lords, Tumkur mediation. Tumkur. 22. Grateful.
My lord, serial
My
number 28.
My lords, a small submission, my lords. My lords, WP, this was listed on 23rd for judgment, my lords, because of shortage of time. My lords had told the matter to be listed today, and the matter is not listed, my lords. My lords, I appeared on that day, my lords. Today's date is reflecting, my lords. And yesterday also, I moved a memo for to be spoken to. That is also not listed, my lords.
My lords, this is a disposed writ petition. In that case, my lords, there was a open court allegation made by the respondent wife as against me, advocate. And that, whether it is contempt or not, only that portion was kept pending. It was supposed to be listed, date was given, but unfortunately it has not been listed. I'm requesting for that case to be listed, my lord. A judgment has been passed by Justice Yadur, no, with respect to contempt, because it is not kept as part heard. Because I inquired with the pending, they said, apologies for it.
Here for respondent. Sorry, my lord, yesterday I could not be. My lord, jurisdiction, in a nutshell, if I have to tell that the decree, divorce petition filed in Mandya, which was allowed, and it was set aside by this Honorable High Court, and subsequently it went to Supreme Court, and after a long trial, after a long time, it was done. Yeah. Yeah. No, yes, my lord. No, but in the meantime, in the year 2016 itself, 2016, have filed a restitution. In that, there is a specific direction, my lord. There is a specific finding. In my rejoinder, my lord, I have filed page number 29. My lord. Yes, my lord. Yeah. Yes, my lord. 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 Yes. Yeah. Yeah. No, my lord. I'll read section 25 once again, my lord, for the benefit. Yes, my lord. Yes, ma'am. Yes, ma'am. There is no such direction or observation made in the Supreme Court. Yeah, no, but that's the reason why I'm mentioning. Yeah. No, it has three components, my lord. The only that I wanted to highlight, my lord. The section 20, this section 25 has initially three components. Whether I satisfy the three component, that's what I want to elicit before this court. Yes, permanent alimony and maintenance. Any court exercising jurisdiction under this act may, at the time of passing any decree or at any subsequent thereto. That means there are three requirements. Any court, any decree, any time subsequent to the decree. Now, decree, as it is said, my lord, section 9 of the Hindu Marriage Act, where restitution of conjugal rights was preferred, there is a decree passed. Any court that passed a decree, Section 9 is a decree, and therefore I am before that court. And this was pending. Yes, ma'am.
So that interpretation will not.
No, even otherwise, Section 9, even section. My Lord, one submission is my petition of restitution was pending in 2016, my Lord. At that time, I cannot be pleading for 25 because my intention is to rejoin the petitioner. Yeah. So therefore, the Honorable High Court gave me an option that Supreme Court gave me an option that you seek, but there is not much mention in that. But second option, my Lord, what my learned friend is arguing is, in my petition, which I have produced, the petition has been produced before this Honorable Court, seeking under Section 25. The prayer is only for grant of alimony only. There is no schedule. The territorial jurisdiction, he is saying that the lands which are situated, they are in Srirangpatna, which is in Mandya district, my Lord. So I have not made any prayer. Yes, my Lord. No, he has said that because IA what has been filed, in that IA, the lands are situated, so temporary injunction has been granted not to alienate. On the date of presentation of this petition under Section 25, he had not even discharged the amount as ordered by the Supreme Court. So amount was not paid by him. So therefore, that was in that context, my Lord. So therefore, I am. Yeah, and there is a clear finding in both the cases. There is a finding, my Lord, because it came up before the same judge. In the petition, what is now impugned before this court, there is a clear mention that have challenged only the alimony part only and not the territorial jurisdiction. So therefore, that was the context, my Lord. If further on this regard, my Lord, Justice works on Supreme Court judgment, my Lord. Under 24 and 25, my Lord, under similar facts and circumstances. So, regarding permanent alimony and Section 24, so this was a referred matter. So there also it was of the same view that what is a decree. So Section 23 of the Hindu Marriage Act says, in any proceedings under this act, whether defendant or not, in the court as satisfied. So this has been clearly mentioned, my Lord. Therefore, I wanted to relay. If time is granted, my Lord, I'll elicit on this. Primarily, it comes on the para number 14, my Lord. Now we come to Section 25. 14, my Lord, para number 14. No, it speaks about the decree. Yeah. Yes, ma'am. It confers rights on the spouse of the marriage declared as void under Section 11 of the Act to claim maintenance from the other spouse. The remedy is available to both husband and wife. The principles which apply to Section 125 of CRPC cannot be applied. Yes, ma'am. Yeah. Yeah. This was the latest one, so therefore I thought I will rely on this.
One submission, my Lord. Regarding, my Lord, 20 lakhs deposited, my Lord, before the Monday court, my Lord, on 70. Yes, ma'am. Please, my Lord. MC. No, senior civil judge Mandya. MC number 6 of 2009, madam. No, synopsis
26.
26 of 2009. Page number 1. Page number 1, madam. MC number 26 of 2009. Two 2014, madam. 2014.
The same is challenged to the right by filing MFN across 7/2014 and on 30 and 2014. The disseminate filed to the right is allowed by the disseminate court on 26/4/2016. Challenging the same, husband had to record SFC with civil number 3473/2016 before the honorable ethics court. They have the right to file a permission seeking restitution for conjugal right, that is NC number 2470/2016 on the final declaration of recognized. The SNC was allowed by the was allowed. Then on 23/11/2022, the ethics court has allowed the appeal filed by the and has affirmed the order of the high court on the high court with the degree of divorce is granted. However, the court granted interim alimony of rupees 20 lakhs, reserving liberty to the respondent to file the application at a 25 legal matter for determination of alimony. Then thereafter, on 12/1/2023, the 1.5, the state is number 08/2023, on the basis of the pure edition and family court at Mysore.
Bangalore. Bangalore. I corrected.
Bangalore.
Bangalore.
Bangalore, case is public delivery of rupees 2 crores. Then the petition husband has filed objection stating that the court that Bangalore handle jurisdiction and the properties of the created and the right that the resident board will go before the court at Maya, which has granted a degree of divorce. The family court, by order review, has discussed the said application. By discussing the application, the court has observed that the wife had come up with a petition under section 25 of the New Marriage Act. In furtherance, the orders asked to the ethics court seeking for permanent handling of this divorce. And she has produced the documents relating to the property available to the property belonging to the petitioner to the wife husband and his family members in support of her case to establish the financial status of the husband. The wife has not sought for any relief with respect to the property belonging to the husband and his family members. They rely upon the document only for the purpose of establishing the status of the husband in support of a case for the purpose of determining the matter of permanent handling for which she is entitled. Having the right of child petition that says in number 2430/2008 seeking the certificate of conjugal rights before the very same court. At that time, the husband has not disputed the jurisdiction of the court. He had participated in the proceedings, accepting the jurisdiction of the court. Since of victims that placed by the husband regarding the jurisdiction of the court, that he had case on hand, 525 of the Indian Marriage Act cannot be accepted. And accordingly, he said objections or rejected. The counsel referring to the husband submits that the husband has filed an LC seeking divorce on part of the family court, serious judge court, Manya. Court has passed the judgment and that is carried the honorable ethics court. And the honorable ethics court has affirmed the order. In those circumstances, the court, the petition has to be filed for an annulment before the court takes Monday up. And but not at Bangalore, where a restitution petition is filed. We had, the line of the judgment.
Yes, my lord. Kolkata High Court.
He has relied on the judgment of the Calcutta High Court in case of Samir Ranjan Chandra versus Deepika Chandra, reported in 2015. 2015 to Calcutta Law Journal 388 and submits that is relied on paragraph number 11. 12, 13, and 14. Wherein the court, in the similar circumstances, has taken the view that the party ought to file an application under section 25 of the Act, where the original decree for divorce was filed. And it is also observed that it is needless to mention that the substantive of these paragraphs is. It is needless to mention that the substantive sections regarding divorce, etc., of section 9, 10, 11, 12, 13, 38, 13, and 15. Section 25 or 27 is incidental in nature, deriving source from the original decree to divorce. Thus, the application as section 25 Act as filed was not maintainable before the district judge and would set forth relying on the judgments from the council of petition of the side. The court had tried to consider the scope, the tried to consider the fact in the light of our past on the level scope. The court is Bangalore jurisdiction. It's the council had ready to respond and try to address that. The party already filed a petition for restitution for conjugal credit. There, at that point of time, the husband has not raised any question regarding the intended. Before the very same court, they filed this application, and the wife has filed the application under section 25, seeking for immediate tenancy. Their counsel of the staff, that the counsel has drawn the attention of the court to section 25, and the subject staff. Any court exercising jurisdiction under this act may, at the time of passing any decree or at any time subsequent thereto, can make an application and that the court can consider this. It is a submission to the council that the court, when the court had already passed a decree of restitution. Now the application that is filed under section 25 of the Mediation, seeking convenient alimony before the said court is maintainable. We have relied on the judgment of the
2025. It's 2025 ACC.
is relied on the judgment of the apex court, which is process Supreme Court, reported in 2025 SCC online, SC 299. Is submitted that what is the decree, what is the scope of a petition under 25 is elaborately discussed in the honorable apex court. In the light of the same, the courts at a final of jurisdiction, court had rightly considered and pass offers, no interference is for next. The council on the whole task of the council applying to further respondent is on section 25 of the Hindu Manifesto. Section 25 1 of the Act. Section 25 of the Act reads the extract 25 Hindu Manifesto. And according to the council, that as the restitution, the decree of restitution after the courts extra, and that after the very same court, when they have to expand this application and there is no the husband has not raised any issue with regard to maintainability when the institution petition filed. The order of the trial court in the subject may not be sustained, and the argument of the counsel the respondent has no for the following reasons. This is not a case where the wife is coming up with an application for permanent delivery, independently, subsequent to the user of the system. Here, the husband is filing an MCQ of divorce in Australia. Same was allowed. Finally, reached the Supreme Court. And the Supreme Court has affirmed the findings of the courts at Madras and fixed an interim and the parties to overcome the limit. In those facts and circumstances, and basing on the said order, past benefits for this application is removed. In those circumstances, it is necessary that the wife has to do the application for the very same. Now, it is a finding of the court that she is not seeking any relief with regard to those properties. It is also an admitted fact that the husband is staying in India, and he has also placed on the cost of the property show that the husband is having properties at India. This observation of the court, she is not seeking any relief, but only for the purpose of doing things she has to show that he is capable of paying the property person. When once a decree is passed by the court and the permanent alimony is granted, and when there was the husband fixed to pay the amount, there has to be execution consent, and the properties are located within the jurisdiction of Andhra. That is one of the reasons. But the prime reason for which that has to be filed before the court at Madhya is includes the receipts that is filed before Madhya court and which is a formal letter court. The consider opinion of the court, the family court and so on, find the finding that the court that family have to do that to the matter.
Miscellaneous number 8 of 23. IA number.
IA number 1.
1 minute.
1. Because that was the only IA which was filed seeking, usually the IA seeking permission to continue.
IA number 1 minute.
Appearing for the petitioner, Milods, may I seek a pass over, Milods?
How many times what has happened on the last occasion?
Milods, the matter was listed yesterday. It reached a little later in the evening, Milods. That's why the Honorable Court directed it to be listed today, Milods. I'll come at 2:30 and argue.
For the petitioner in this case.
My lords, I'm up here for the respondent.
We are
Kindly pass
challenging-
over, my lords. 2:30.
Last week, 3 times had come, so I had requested yesterday to keep the matter at the top of the list.
Please, my lords. 2:30.
Please.
I'm appearing on behalf of the petitioner, my lord.
Appearing for respondent, my lord.
Ready for arguments, my lord.
Pass over, my lord. Ready, my lord. Ready, my lord.
My lord, in the afternoon, I have several part-heard matters. I'll try my luck today, my lord. Pass over.
I am for the petition. The respondent number 1 is the wife of the petitioner, and respondent number 2, their child. The 4th Additional Principal Family Court, Mysore, awarded rupees 6,000 to the petition number 1 and 4,000 to the petitioner number 2 And therefore, I have filed this petition for reduction of the quantum of amount awarded to the petitioners. Yes. Yes. Yes, my lord. Yes, sir. My lord, the observation of the family court may kindly be perused at page 21 of the main petition. Page, page 21 of the main petition. So it is a judgment passed by the trial court. $4,000 to the petition number 2. I think. My lord, page number 21. No doubt from the exhibit 5, copy of the point number, page number. Paragraph 14. Yes, my lord. Regarding the source of income of the respondent, it is stated that the respondent is working in a private firm and drawing salary more than rupees 40,000 per month. Rental income of rupees 30,000 per month and agriculture income 2 lakh per month per year. It is relevant to note that except the pleading, absolutely there is no documents produced by the first petitioner to show that the respondent is working in a private firm. There is no any document, my lord. She has taken a false plea before the family court to show that the respondent is working in a private firm and he is drawing salary of rupees 40,000. My lord, it is totally false. Further, the first petitioner has not produced any document to show that the respondent is getting rental income of rupees 30,000 per month. The observation of the family court. Added to this, the first petitioner has not produced any document to show that the respondent is having landed properties and he is getting agriculture income of rupees 2 lakh per year. My lord, he has no any agriculture property. Yes, my lord. Absolutely, there is no documentary evidence to prove the income of the respondent. However, it is to be taken into note that as per the cast title of the petition, it shows that the respondent is aged about 37 years old. In the absence of any contrary material placed on record, this court is of the clear view that the respondent is aged about 37 years, and even if it is considered that the respondent is doing coolie work, laborer, my lord, then his monthly income is to be presumed at the rate of at least 15,000. It is relevant to note that the petitioner has clearly pleaded that in the month of January 2020, the respondent has yes, my lord, the respondent number 1, even she has not filed the assets and liability statement before the family court. No, my lord, the family court has awarded 6,000 rupees to the petition number 1, and it is higher. Yes, my lord. Yes, my lord.
I appear for the first, I appear for the respondent in 6.1 and for the petitioner in 6.1. 6, my lords. So, sorry, I'm the respondent in 6, petitioner in 6.1.
Please.
For the husband.
Please. Please. Impute this order about interim maintenance, final order of maintenance. Page number 53, at the rate of 25,000 per month from the date of the petition, till modification for setting aside. The marriage between the parties is 11/9/2020. Parties, wife is from Mangalore, husband is a doctor in Bangalore, working, and resided together for some time, and thereafterwards she was thrown out, is her contention. And then she took shelter in her parental house at Mangalore, and she continued. She is also a doctor, MBBS at that time, and she continued her studies. And to the relevant point of time, my lord, she was doing her post graduation. And as far as the husband is concerned, he is MBBS, MS Orthopedics, and he has also fellowship in pediatric in bone surgery. He is working in Indira Gandhi International Hospital, Bangalore, also running other clinic. Now, as for the wife is concerned, my lord, during the relevant point of time, she was doing her post graduation. Now, my lord, with effect from April end, that's May onwards, she has completed and she has got employment. May 2025 onwards. The exact date, my lord, when she got the employment is 29th April 2025, after the filing of this. So therefore, we restrict our claim for maintenance only till that date, my lords. Petition is filed, my lord, 2021. The date, exact date is, my lord, 13/12/2021. My lord, during she got admission in for a post graduation in Mangalore, my lord, and our parents have spent 9 lakhs rupees, etc., for the fees for the admission. And during the period, my lord, of her stipend is also prescribed, my lords. And her post graduation stipend is first year 45,000, second year is 50,000, third year is 55,000. And situation this for as far as got into the PG, my lord, 22, now completed in 25, 3 years course. Please. Now, my lord, this order, my lords, this is considered by the trial court, my lords. This is mentioned in the order. My lords, its expense is this. As for microbiology is concerned, my lords, her contention itself is for the education purpose itself expense more than that. She has to attend many conferences also. Each conference will be 10 to 20,000 conferences, and she has to present papers every month. At least 2 papers have to present it as far as microbiology is concerned for the post graduation course, my lords. One is that. Secondly, as expenses much more than this. This is whatever that's being paid is nominal, and she has to attend 4 colleges there in different places. The expenses much more. 125. It's only the please education. Your lords may kindly see, as far as the expense, educational expense itself is huge, my lords. He has not. 125 for her to please. No, I will not say anything else. I will only say basic needs. He let it, as far as my lords may submit like this, my lords. As far as educational expense is concerned, we consider parents are taking care educational expenses, and the stipend maybe to some extent that will meet to some extent it will meet the educational expenses to some extent, not completely. As for educational expenses, for living, her living also husband has to pay. And one more aspect is, at the time of marriage itself, my lord, the understanding was that he will provide her education, etc. We will not insist on that now at this stage, my lord, that he should provide the complete finance of the education. We will not. Now, as far as her living is concerned, my lords, that itself is as bare expenses. She should lead the life of to the standard of a husband. She doesn't have any house of her own, even at that stage. Yeah, hostel expenses, etc. are very huge, my lords, as far this aspect is concerned, my lords. Now the stipend which is paid is insufficient. Educational expense you have mentioned, it runs to several lakhs, my lords, including this one. We have not claimed it against her. Now, my lords, one aspect is about the entitlement and what is the quantum, etc. is one aspect, my lord, that we fairly concede with the effect from so and so date, my lords, we have got employment. And till then, our submissions, we prayed for 75,000. The trial court granted 75. We are praying for enhancement before the small court. We prayed for 75. The trial court granted 25. We are before the small court for enhancement. My learned friend is before the honorable court for cancellation of this. In the meanwhile, my lords, there is also one petition filed for divorce, which is pending by the husband. Why the wife has opposed it, and wife has prayed continuously. She has been praying that there should be restitution. Prayer is made, my lords. I want restitution. Is the prayer made? I'd be obliged, my lord, if there is some, if she instruction is, my lord, she is ready to go join the husband. Now he is a doctor here. She has got the job now here in Bangalore.
My humble submission is, my lords, the marriage lasted only for 3 months. She walked out of the house. I've produced the email communication which clearly shows that she was not interested in living with the husband. Email communication is produced is before your lordships, which speaks for itself. Long email, which clearly shows that she was not interested. Yes, my lords, in my petition. Page 244 minutes. 244 minutes. She writes such a long email, my lords, which very clearly shows that the marriage has been broken down irretrievably. Very first paragraph, my lords, makes false allegations against her mother, his mother.
Okay, cost is not. Cost is not survival.
Milords, it's after this mail that she actually leaves the house and she, Milords, Milords, marriage was on 11/9/2020, Milords. She leaves the house on 28/12/2020, Milords. So only 3 months and odd, Milords. Milords, my humble submission is, Milords, the entire mail, Milords, in fact, such a long email. In fact, Milords, such a long email. Milords, my humble submission is.
Because both are doctors, my lords. Luckily, doctors have written by typing, my lords. Otherwise, doctors' handwriting is impossible to read.
It's around page 44 to 265, my lords.
So must be so intricate and just so many things. And her instructions are, my lords, that she has misgivings only about the mother-in-law, the taunts and abuses by the mother, nothing about the husband. And she continuously said.
Milords, my humble submission is absolutely, she's not ready. She wants her out of the out.
Now he was studying here there, she was studying there. Now she has got employment here. So she says, my lord, she has got employment here. Today she is not present, my lord. Today she is not present, my lord. If lords permits direct, my lords, on any particular. Both are doctors, my lord, so that. Your lords may kindly fix up any day in the next week if it's convenient. How? Please.
Fourth, Milords, fifth, there is some inconvenience. Fourth, Milords.
Yavara? Monday na. Please, much great.
Okay, for the petitioner. Lord, what is? Lord, there are two other writ petitions, one filed by the husband and the other one filed by the wife. Proceedings, sorry, there are three now. One was for the visit, sorry, another two. This is challenging the order of maintenance passed by the family court. Both the husband and the wife have challenged it. 8.1 and 8.2 are those two petitions. 8 is the first petition filed by the father, my lord, was asking for visitation where your lordships intervened in. Now they have the shared parenting plan that is in place, 15 days each. Not, my lord permits the family court while awarding maintenance, 1,50,000 is what is awarded now. Lord, I had also filed two applications for production of documents. No, not heard, sir. Not heard.
We don't have their petition papers also.
Both are coming up for the first time.
We have only one concern today, my lord. Lord, in the main matter, your lordship passed an order on 29/4/2025. Wait. In the other two writ petitions which are challenged, my lord, there was no hearing on the maintenance at all. Still, my lord, the order was passed. Therefore, we have passed. Lord, 29/4/2025. Lord, the last paragraph in that, my lord. Trial court shall dispose of the application criminal miscellaneous 170 of 2023 before the MMTC Mayor Court as expeditiously as possible, provided as per the orders passed by the court, all the documents are placed by both the parties. My lord. Now this order, my lord, after this order, my lord, there was a hearing, my lord, where, my lord, the court has passed an order directing, my lord, both parties to provide the documents, my lord. We have already provided. They have not provided. There is an order passed, my lord, that if they do not provide by the 16th of August, my lord, then the documents will be summoned from the employer. Now, my lord, till today, they are not complying with that. Now, what they do, my lord, so that the DV court does not proceed with the matter, they file an appeal, criminal appeal number 24256 of 2025, challenging an order dated 6/4/2024. 1 year, 1.5 years earlier order, they want to challenge so that they can obtain a stay order. Now, they are not permitting. From 2 years, my lord, there has been no orders on my maintenance. One way or the other, my lord, it is being, my lord, dragged on by this way, my lord, by asking for production. These very documents, what they have asked, my lord, has been produced before the family court almost in December 2024, my lord. Still the same IA is filed. We comply because the same documents are sought, we comply. Now, my only, my lord, the prayer to your lordship is please direct, my lord, that some orders are passed by the court, my lord, so that on this IA number. Yes, my lord, that will. Yes, my lord.
That is for the.
Lord, the order is on.
Yeah, one second.
Lord, our single ground in this writ petition is that this IA was never taken up for hearing. Matter was never considered on merit. Yes, yes, my lord. Lord, this order was never, Lord, it was not after hearing. Nothing was considered. No, we were before your lordship, my lord. We were before your lordship. This order was placed along with a memo before your lordship. Since your lordship was, Lord, seized with the matter, we did not choose to challenge it. But, my lord, tomorrow I don't want it to come against me that you never challenged that order. Therefore, we filed, my lord, the writ petition. Lord, this order, my lord, merely, my lord. Yes. But there was no hearing on this, my lord. And there is an observation in this order where it says that, my lord, the wife has independent income, which is against the material on record.
If my lord takes my writ petition, my lord, also challenge them.
No, there
Yes, the very same order even I have challenged. The next writ petition. Lord, there the family court says that the wife has independent income. It's apparent from documents, but she is not produced all documents before the court. Therefore, she is directed to place not all documents. I had filed 2 other applications. The family court directs her to place the documents, but at the same time passes the order of maintenance without awaiting those documents to be produced before the court. And matter to be remanded, let her place the documents on record and let the order be passed. But so,
no, I have already filed.
My lord,
A to W they have asked.
With great respect, my lord, what the learned senior advocate is referring to is a domestic violence proceeding where the wife has filed one more application for maintenance. She has filed application for maintenance in the divorce petition. She has filed application, a separate proceeding under 125 CRPC, and in the domestic violence case, my lord, before the magistrate, there also she filed an application for maintenance.
None of them are ordered. I have not getting a single rupee. For last 2 years,
the family court has now awarded 1,50,000 rupees per month in the 125 proceeding. There, my lord, I had also filed an application for production of documents by the petitioner. Family court holds. My lord, I listed the documents, my lord.
Same IA is filed before your lordships. We have produced those documents here also.
Sorry, those documents are not on record. They're not on record. Lord, in my writ petition, my lord, that order has become final. The respondent does not challenge the order. Page 33, my lord, annexure C.
Sir, I have the file. Please give me. Soft copy.
These are the documents sought for. May I read, my lord?
Soft copy.
Bank statements, ICICI and Bank of Baroda have not been produced, my lord, along with the AOD. Yes. 33, my lord. They have not filed objections.
No, I have no objections. I have produced.
Not produced.
I have produced every single document, Lord, A to W.
Kindly see page 25.
We'll give the compilation. Lord, the date.
Before the DV court on 19th of.
DV court. Family court.
Lord, that is filed in December. No, in the family court, it is filed in December. Lord, in DV court, it is filed, the same documents are filed in, Lord, on 19th July. Same documents, Lord, if your lordship sees those 3 IAs, Lord, which my friends have filed, Lord, it is the same documents which is asked in 3 different courts. 3 different courts, Lord, we have produced. We'll give the compilation. We'll give the compilation tomorrow, Lord. We'll bring those documents.
If they file the documents, and the family court can proceed on the basis and pass.
Yes, now the problem is this, Lord. Now they have not produced the documents which we are asking. He has changed. Lord, the order, Lord, is at page. No, give this compilation, please. What has happened is he has changed his job. He is now employed elsewhere. Earlier he was employed in Ernst & Young. Now he is employed with a company called BDO. So we have asked, since there is a change, please produce your documents which shows. Lord, give me the IA.
It's yours. IA, page
Yes,
number 48.
please, page number 48.
Lord, very well. Yes.
You also.
May I make this request, my lord, to make it more clear, my lord, to the respondent so that they know what documents to produce. I have filed an application before your lordship giving the account numbers because that on 19th of October.
Yeah,
given. Just now. Yes, this IA has been allowed by the DV court, my lord. It's on 16th. It's on 16th of August. Yes, ma'am. Correct. Yes, ma'am. DV court. It's a DV court. Can you see page 48? Traffic court, First Metropolitan Magistrate Traffic Court, not family court. Nothing is filed.
No, is there an application before family?
They have not
Yes,
filed
it is
before
not
the
in
family
family
court.
It's not yet ordered. There is the same application is filed.
Prior, filed much prior. It was never taken.
No such
Not
application.
yet taken up.
My lord,
No, exactly, my lord. Your lordships were suggesting the most correct thing, my lord. Let them produce here before your lordship in the next week, my lord. Lord, 16th August is much far ahead. Before that, my lord, all the documents will be before your lordship.
Lord, we have no problem. Lord, may I make one request? Before your lordship will place all the documents. Lord, may I make one request, my lord? I have filed an IA on 16th. Yes. Yes.
And both of them submit that they respect their respective parties have already filed. To put like writers into this conclusion, the husband shall file the documents which are sought by the wife in the First Metropolitan Magistrate Court in Bangalore, criminal state 170 of 2023. The list of documents are running into
On page 48 and 49.
All the documents that are stated shall be produced. Then with regard to the wife is concerned, the husband has filed a petition before the 6th Additional Family Court in Bangalore. An application under 9 And he has sought for as many as
A to W.
10 documents.
No, my lord,
Again,
more.
they've split it
Huh?
in between, they
Okay.
split it between two IAs.
A to W, as far as I remember.
This,
All those documents have to be before
2 weeks.
I can produce it next week, my lord. They are ready.
No,
We have
DV
already
code-
filed it. So for me, that is not a problem. It's only Xeroxing for me.
we have date on 16 for DV.
I will try. I'm not, if the documents are available. No, not maybe. I have one request. I have 17th of August.
No,
16th is DV code. He wants to
16th
delay.
is the DV code.
Previous employer, I can't produce them right away immediately. It takes time.
16th is DV code hearing, sir.
Not on 19th of October, just to specify, the account numbers have given. 19th of October, I had filed an application before your lordship, which is pending. In 16445 of 24.
It is the same thing as this IA.
19th August, that has got the exact details of the account numbers, the statements which we require. Because before none of the courts, those documents have been placed on record by the wife. 19th August, 1910.
It's there at
Sorry,
page
19th
58.
October, 19th October.
This compilation that we gave just
Sorry,
now,
1 second, sir.
it's at
1
page
second.
54.
Sir, 1
Kocha,
second.
this is before DV code. No, the same. No.
19th October.
No, sorry, it's not the same. No, it's the same documents, but this is filed before the DV court at page 54. And the documents that are requested are at page 58, A to W.
Same thing there as well.
We can just do it now. The corresponding years are not.
Same, it's the same.
Same. No, we have produced it here also. We made a compilation.
Another court has ordered for some other one.
Yes.
So it is now, we say, whenever small documents that are
58 to 60.
that are filed, that an application is filed along with the memo, in page number 54.
Yes.
Now, the husband has sought for as many, and I sought for certain documents. As per the said list, the documents that are produced.
Obliged.
And as far as your concern, that is.
Yes.
Yes.
Obliged.
Lord, they may continue to pay the thing in time, Lord.
No, we are paying. We are paying.
Some delay.
We are paying, we are paying it every month. We are complying with it. But may we make one, 18th I'm not in station, 19th if it's
Very well.
obliged.
19th, Tuesday.
Sorry. Sorry, my lord. He says he's been paying around 1 lakh on the 1st or 2nd of every month and 75,000 rupees after about 8 or 10 days. Your lordships have directed him to pay before the 5th. But he's only paying it in 2 installments before the 7th of every month or 10th of every month he will pay. Before the 10th we are paying.
Before the 10th.
By the 2nd or 3rd of every month he pays 1 lakh. By the 10th or 12th, not he's paying every month he's paying. Yes. Obliged.
For the petition.
Yes.
And my application is filed seeking amendment to urge additional grounds along with the documents has been placed before this court. Those documents are very much necessary to substantiate my case. Yes, madam. This is the interim order is at page number 11, annexure A. And my lord, before that, my lord may kindly produce the annexure D page number 28 for a moment, my lord. This is the petition filed by the grandparent. Yes, madam. Yes, madam. Yes, madam. Yes, madam. That order passed with. Sorry, madam. Order is, my lord. Yes, ma'am. Petitioners are the grandparents before the trial court, and the present petitioner before this court is, my lord, the mother of the ward. Mother, the natural guardian. Lord, kindly come to the, I challenge this order, my lord, granting the custody, interim custody of the ward on every weekend. Father is no more. He died. He's died on 4/8/2022, committing suicide. Difficulties, my lord. That's what, my lord, I try to explain to this court, my lord. Kindly come to the Annexure D. This is the petition filed by the grandparents, page number 29, my lord. Paragraph number 4. Right, it is submitted, I may permitted to read out. It is submitted that after a few months of marriage, the respondent started to harass the petitioner's son by giving mental and physical harassment, by abusing, misbehaving, insulting, and maltreating. It is submitted that the petitioner's son made his efforts and tried to mend the ways of the respondent, but behavior and attitude of the respondent remained unchanged, indifferent, adamant towards the petitioner's son. It is submitted that on many occasions that the respondent left the matrimonial home without intimation or knowledge of the petitioner. Yes, my lord. Yes, my lord. The allegations and prima facie shows that, and the subsequent conduct of the grandparent will substantiate that this impugned order. I am not against the grandparents meeting the child. I'm not against that. Let them meet it. Let them meet in my house. Let them visit in the place or the family court where the now matter is pending before the family court at Bangalore on every Saturday or alternative Saturdays. Age is, my lord, now is for 5 years. 5 years. He is now admitted to the school at Bangalore. He is studying now. My lord, the death was on 4/8/2022. Earlier also they were not residing. They are residing in Bangalore. I mean the wife and husband. I mean the present petitioner and her husband were residing in Bangalore. They were not residing in the grandparents' house at no point of time. Of course, they had relationship. Grandparents are residing now at Pandupura Taluk, Elakare village, Kasba Hubli, Pandupura Taluk, Mandya district. It's around 120 kilometers from Bangalore. Boy has to go there on every weekend, Friday evening to Sunday evening. Yes, ma'am.
My lordship initially filed the petition before the Pandupura court, my lord, jurisdiction of the child, where reside in the Pandupura limits, my lord. Subsequently, after passing the order, my lord, by suppress the facts, after passing of this order filed before the formal court.
He is making allegation that after admitting the child to the education, I mean kindergarten. Let me submit. Let me submit.
Brought to the notice of
Let me submit, sir. Let me submit.
Yes, please.
I have filed a civil petition before this court seeking transfer of the petition. Now the petition is now transferred from Pandupura court to Bangalore court. That's what I am submitting to the court. Now the court, family court at Bangalore is adjudicating the petition in accordance with law. I am not against. Let them come and visit my house only. Let them see the child. Let them visit on every weekend or any Saturday or at the family court at Bangalore.
Please. Because, my lord, respondents are aged grandparents. Because no, my lord, petition completely avoid the child, my lord. Since from the order also they did not comply the order, my lord.
Yes, and my lord. Yes, ma'am. Yes, Saturday we are ready to bring after school hours.
I'll keep party present before the court in day after tomorrow. Because party's difficulties, my lord, they are stayed in rural area, my lord. They are not about the Bangalore knowledge, my lord. Yes, exactly. Or else, my lord, I will pick up the child and hand it over to the petitioner. Or else alternative week I request to the Honorable Court. Or else alternative, because the respondents only state. No problem.
May I make one sub, ends is fine. Yes, ma'am. Yes, ma'am. Check.
Once in a month, I agree, my lord, but in other visiting hours, my lord, several mediation occasion before the trial court, my lord, the number of issues.
Please find out which I'll just pass over to 5 minutes. You find out from your friends, when is it convenient? Whenever it is convenient, because the boy comes back, any other day, not necessarily the examination. Tell them it's convenient, you will pass them on. So, and like that, whenever you come to Bangalore, you can visit. After some time, after 1 month or 2 months or so, once they develop the system, then they will say, once in a month, Friday to Saturday, they can take it to Monday.
Please, ma'am.
Get it, sir.
Please, please.
I call the fund and tell you.
Get it.
Otherwise, you take the cost. Say number, say number 10. Say number 10.
Serial number 11. I'm for the respondent in this matter. Matters.
Out.
Oh, sorry.
The court notice on the matter came up on 18/7/2025. This court has directed the matter to be listed for dismissal. And the court has also observed that the court notice is served on the petitioner and there is no representation. Today also there is no representation. Today the petition is not introduced to the police person. Dismissed for non-prosecution.
Cell number
11, what has happened?
The divorce has been granted, my lord. I'm for the respondent in this matter.
The matter is settled for the third additional family court.
Memo is filed stating that.
Move for withdrawal.
And as well the petitioner does not want to proceed the matter. NC number 4121/2019 is already restored, is already settled.
Just withdrawal.
NC does not want to proceed the matter. Accordingly, dismissed as withdrawn. Memo is taken on the court. Yes, right.
Cell number 12.
Published.
Cell number 12.
Petitioner, kindly pass over, my lords.
Cell number 13. Kiran BS.
Appearing for the applicant, my lord. There's a memo for withdrawal that we want to submit.
What happened at the NC?
The other case in the guardians and warden court has become infructuous.
Stating that, memo is like an affidavit.
Sorry,
Memo is containing so many facts.
we are giving the entire sequence.
The dispute between the parties is settled. The memo is taken on the court. Yes, next.
Cell number 14. Anaya Rai for petitioner.
I'll respond in the next week.
Kamaloli.
Next week.
On 24/7/2025, the matter is listed, there is no representative for the petitioner. And then an officer respondent is present. Today also.
14, sir.
Today also there is no representative. They have the petitioner. Officer respondent is present. In spite of the fact the matter is appearing in the cast. Hence the petition is not.
Cell number 15.
Present the petitioner in this matter. The order, my lord, impugned order is on an application filed by the minor children in a petition under section 12 of the Guardian and Wards Act for custody. Father has filed for custody. The minor children who are arrayed as respondents sought for maintenance. The trial court dismisses, my lord, the application solely on the ground that under the Guardian and Wards Act, there is no enabling provision to grant interim maintenance. That is the sole ground on which the application has been rejected. The children are in the, my lord, they're under the custody, admittedly they are under the custody of their maternal grandparents. Their mother died by suicide long back when they were infants.
Respondent is an agriculturist, my lord. He has a mere. There was a criminal miscellaneous that was filed by the petitioners herein and under 125 CRPC, wherein they had compromised saying that the custody will be with the maternal grandparents and he will pay a maintenance of 12,000 rupees each every year. Thereafter,
No, yes, there is that agreement is at Annexure B.
Then how can you seek the maintenance again?
No, there was a compromise. He undertook to pay school fees and maintenance annually. That he is not paying.
But then you have to file an execution.
Execution is pending. And no, my lord, the school fees is not paid. Each year, my lord, the grandparents are being saddled.
For that, different proceedings cannot be initiated. If there is an order and that order is not complied with, you will not file another fresh petition for that.
there is another criminal miscellaneous pending wherein arrears are also paid, my lord.
You will seek for the execution.
My lord, the execution process, each year I have to go on filing a new execution.
But it is not a relief.
My lord,
You have entered into a compromise.
but, my lord,
You have entered into a compromise that is binding on both the parties.
kindly see that Annexure B, my lord.
Yes.
This is a my lord, gross breach of undertaking made by him before the family court.
In that case, you have to
My lord,
before the appropriate court.
he is now seeking custody without paying a single penny to his children. My lord, he is happily, my lord, he is remarried with children. And my lord, they are under the,
Please come to your memorandum of understanding.
yes, kindly turn to page 17. Page 17, paragraph 3. The respondent has agreed to bear all educational expenses, including future, till the petitioner complete their education. It is agreed respondent will pay admission, tuition fees, etc. directly to the school. Impugned order at page 14, my lord. I only go to the last, that is the crux. My lord, the third line from the bottom, the petitioner father has filed the main petition seeking custody of his minor,
526 of the Hindu marriage.
read with section 151.
What is this meant? See, what is this Hindu marriage act? It's a guardianship to GNWC.
Yes, my lord, the provision was
That
wrongly
is the
quoted.
ground on which the application is dismissed, saying
My
that
lord,
there
wrong
is no
quoting of the
problem.
provision cannot be a ground to reject. Section 26 of the Hindu Marriage Act deals with the custody of the child and also maintenance, but it is pertaining to proceedings under, ma'am, kindly allow me to submit. Hindu Marriage Act, moreover, here in between the parties, already there was a settlement and they shall act in terms of settlement. In view of these reasons, I am of the opinion that the grandfather of the respondent is not entitled to. The grandfather is not trying to, my lord, seek for maintenance. My lord, it has become virtually impossible for us to execute this order. My lord, every time a warrant has to be issued, my lord, there is an undertaking to provide us, my lord, the share in the joint family properties that he has not done. He is a continuous defaulter.
When he is not paying the maintenance to the children, let the court not proceed with the case.
My lord, with that observation, my lord, yes.
My lord, a submission, my lord, there's a criminal miscellaneous that I have also produced the order sheet and a 480 of 2019, wherein the arrears are already paid and he's paid.
If that is straightforward.
It is paid, my lord.
If it is not paid, you want custody, there is a settlement before the court. In that settlement, you do not honor, and at the same time, you want the court to proceed with your
In the settlement, the guardianship was also decided that it will be with the maternal grandparents, my lord. The reason why I have filed for GNWC is that the visitation was not given to me as per the compromise, my lord.
Your remedy is also filing execution.
We have done the same by filing a GNWC saying I need the custody of the children now and I am paying the maintenance, my lord. It's not that I am not paying.
You also did the same thing for filing IA seeking maintenance.
In fact,
How is this
this writ petition is not maintainable, my lord.
GNWC is also not maintainable.
Yes, my lord, but the thing is, we've already paid the arrears. I have produced the order sheet.
In IA number, what is this IA?
Application IA, my lord, IA.
The IA that is filed at 26 of Hindu Marika, that is constituency is maintenance of 5,000, which came to me and also to reimburse 1,65,175 towards pay to towards the school fee and tuition fee pertaining to the 2000 from 2019 onward. The grandparents are before this court. The grandparents are in custody of the child.
Two children, my lord, two children.
Children are
Now, anyway, the daughter has attained majority recently.
the custody of the grandparents. The earlier in a 125 CRPC proceeding, memorandum of settlement is entered between the parties. As per the same, the father has undertaken to take care of the education expenses and the custody will be with the grandparents. The father will have the visitation. When the visitation was not given to the grandparents filed, the visitation was not given to the father. Father files VNWC. And when as per the compromise, when the father fails to pay the maintenance, the grandparents will file the IA for maintenance.
They've also filed a criminal miscellaneous again seeking for the arrears, my lord, wherein we have already paid the arrears.
And also filed criminal miscellaneous seeking the arrears. When a particular order is passed to the court, if the same is not complied with, the party has a remedy, file an execution, and also to seek further orders under section 151 CPC. Instead of doing that, both the parties have come up with different applications. The court, the court had discussed two aspects. One is with regard to filing of an application under section 26 of the Hindu Marriage Act, with given secrecy. And also the other aspect about the maintenance that is granted and about the joint memo. According to the petitioner, when it comes to the petitioner, you are quoting the wrong provision of the law cannot be a ground to disentitle the party from having the relationship. And when it comes to the compromise memo, he submits that it is very difficult for him to recover the money, hence he has filed this petition. According to the land council, to the respondent, the amounts that are the arrears are already paid. We got both the council, the parties, whenever they want, instead of executing the order, are coming up with successive petitions before the court. The court, the remedy that is available to the petitioner is to file the execution. And also, he has another remedy when the party who has come before the court seeking the visitation is not complying the order of the court.
Custody.
Custody, when he is failed to pay the maintenance as ordered by as agreed upon, the court is not powerless. The court can as well liquid this aspect and pass appropriate orders accordingly. The petition is disposed.
16. Ramesh, Chief of Petitioner.
Your Lordship,
Chandra Mohan K.
I apologize, Your Lordship, I have to make a mention. Your Lordship, in the previous matter, serial number 14, I was appearing before another court, Your Lordship, therefore I couldn't be here before the court. Great.
Yes.
This case for the petitioner. This matter was referred to the mediation, my lord. She is ready to go with the husband, but she is not ready to take back.
No, he is not ready. We tried our level best. He is not ready to take it. But your lordship may kindly see whether this petition is maintainable.
Only thing
They
is, my
are
lord,
challenging.
the joint memo was filed by both the parties, my lord, in the year 2018 on 36,000. We have challenging the interim order, impugned order. That's the joint memo which was filed before the Lokatala. That was accepted by. Sorry. Yes, ma'am.
36/2018.
Yes.
You question that order in the year 2020.
Yes, ma'am.
What is that order, let us see?
Your lordship will get it. Page 27.
27. before the Lok Adalat, my lord, petitioner number 1 present, petitioners 2 and 3 are represented by their natural guardians. So is petitioner number 1 represented also present? Petitioners and respondents submits that the case is compromised and filed a joint memo reporting the same. Hence, in view of the compromise between the parties, the petition is dismissed as compromised before the Lok Adalat. This was challenged before this court, my lord. Well, only the, after that, my lord, he had never taken to the matrimonial house, my lord. No, only thing is, my lord, after the joint memo, my lord, when they both the parties have accepted, agreed.
Not going to all that. Is it the remedy to the parties, the like, the whatever the memo that is filed before the Lok Adalat, if it is not honored,
Yes.
on what grounds the Lok Adalat award can be questioned?
That, let's. No, only thing is, Malada, the arrears has not been paid till today. Only thing is, Malada, no, they will canvass before this. If I filed another petition, Malada, before the other jurisdiction, Malada, they will canvass the same before the same court, Malada. That is the reason liberty may be reserved to file an fresh. Yes, Malada. No, only that that should not be come in the way because they cannot. No, the compromise, Malad, was compromise between the parties, Malad, in the year 2018. Till today, he did not pay not even a single Malad. He is not taken back to her. No, only thing is, Malad, the compromise, Malad. Please, Malad.
Whatever is readily available to them, this will be staring at you. There is no, it has to be, court cannot say that, okay,
No.
an order is passed, that is no significance. The appeal by the representative is filed, seeking the following prayer. It is submitted that a Lok Adalat award is passed on 13th September 2018, whereby the parties have submitted that the case is compromised and filed a joint memo reporting the same. Hence, in view of the compromise between the parties, the petition is dismissed as compromised before the Lok Adalat. When counsel according to the petition submits that when the matter is compromised, the husband is not adhered to the conditions in the joint memo. Husband or wife? You are
Yes,
saying
Wife.
the husband has not adhered to the conditions of the compromise memo. Hence, their question is before this court. The against an award that is passed to the
Jagadish.
the Lok Adalat, the repetition can be filed before this court only on the ground of fraud and coercion. And on any other ground, the same cannot be questioned before this court. The parties to the compromise, if they are not honoring the terms of the compromise, that cannot be a reason for this court to interfere with the award. The petitioner, hence the court finds no reasons to pass any orders in this petition. However, if the petitioner has whatever of the means that are available for the petitioner, or the remedies that are available to the petitioner, it is always a petition is at liberty to pursue the same. Hence, the petition is accordingly disposed of.
Seal number 9, pass over matter, VM Mohan Kumar, NP Harish Kumar.
Party is insisting monthly once take native placement. Monthly once.
And I set aside this order. I set aside this order.
Because Malad.
How can they straight away do it without any?
The respondents only take the child and take care of and hand it over to the mother only, Malad. Monthly once, Malad.
I'll tell the parties, I'll discuss matter day after tomorrow.
Please, Malad.
And this monthly thing
Get-
straight away will not be passed. They have to tell us this.
You know, the acquaintance or intimacy with the boy or the girl, whoever it is, and straight away I'll not grant any order. Tell them.
Other three times he will visiting here only, Malad. Petitioner.
That's what I'm saying. First of all, whenever it is convenient to you, come to either Bangalore and meet the child.
Yes.
Thereafter, we'll pass that order. That's what I said.
Please, Malad.
It can be passed.
Yes, please.
When they are going to come.
Next Saturday.
It is submitted that.
Saturday, Malad, either, I am just proposing this court, Malad. Either they can visit my house or in the alternative, they are not comfortable, let them visit the family court. The child is studying now, and school timings is up to 2 o'clock. And it's almost,
Why should they go to that? You have no difference. They are grandparents. Why should they go to the mediation center?
yes, ma'am,
At
let
your
them
place
visit
or
my
at
house.
at any other public place, they
Yes,
will take the boy.
I'll leave it to your discussion.
For mother is agreed with the order of the family court, whereby the custody is given to the grandparents between Friday and Saturday. It is submitted that the grandparents are staying in Mandya and the boy is in Bangalore. It would affect his academics, as well as it's very difficult for the boy to travel all the way. Learned counsel appearing for the respondent submits that if not every week, the month, every 2 weeks, the custody may be given to the grandparents. They will come and pick up the child and again they will drop them. The right from 2022, from the date of the death of the father of the minor, the minor is residing with the mother. At this point of time, the court is not inclined to grant any custody to the grandparents. First, they have to develop the attachment with the minor in view of the same. On any Saturday or Sunday, whenever it is convenient to the grandparents, they can come to Bangalore. They can meet the child in the place where the mother is residing, or they can take the child outside and they can spend time in any public place for 3 hours. For 3 hours. It should be in advance. It shall be intimated to the mother. List this matter on 1st of September. We'll just see how it is happening.
Please.
On that day, we'll pass further orders.
Great.
Yes.
And may I make once, only grandparents may be permitted to meet.
Grandparents only, who else will
Yes.
come?
Their
Their-
daughter and
Huh?
Their entire family will come.
No, the entire family will see them when he come to Manya. Yes.
Chair number 17 for orders matter. 17.
The notice is yet to be served on the claimants, my lord.
Yet to be served.
Yes, my lord. Says await notice.
What happened? What happened to the earlier?
Even in my case where I have filed an appeal, my lord, they're yet to be served.
We'll see. 2023. I think these MFA matters of 23 and 22 and 23, there are about 6,000 matters for orders. Right for hearing is not even 200. Sir, no. What happened to why the court notice? Supported that Vishnath Pujari learned counsel on record. For respondent number 1 and 4 in the connected matter is no more. When was the notice sent? Look at the office note. 15/7 it is sent. The notice is sent to the parties on 15/7. List this matter on 19th August. Both the matters. Next 18.
Chair number 18.
Case, my lord.
My lord, in
Next matter, why the
My lord,
amount is not deposited?
My lord, it's deposited, my lord. On 3/10/2023, my lord, a sum of rupees 4,78,000.
You are on what ground before this court, on liability or on quantum?
Well, on liability, because on corporation, my lord, 35% is fixed, my lord. He comes and dashes against the rear portion of the bus, and both the pillion rider and the rider, my lord, sustained injuries. And the court and the charge sheet has been filed against the rider of the
So
bike.
35% of the amount is coming to what?
Well, I have deposited to the extent of 50%, my lord. Probably 4,47,000.
No, 50% of your liability.
Yes,
or
my lord.
your liability is?
Liability, I have.
7,58,000.
What is the amount granted?
7,58,590, the liability of the cash addition.
35%. In that they are able to pay 35%.
Yes, ma'am. No, ma'am.
Well,
35% is
my
itself is 7
35%
lakh.
is 7 lakhs and all.
7
Your
lakh.
35% itself is 7 lakhs.
Yes, In that, my lord, I have deposited 50% with interest, my lord.
And that comes around,
Which comes to 4,78,441. Plus this 25,000, my lord, which is
so
deposited.
anyhow,
I think, my
even
lord-
if after hearing the matter also will
But
not
I think,
completely
my lord,
say.
because the person who died is a rider, my lord, sorry, pillion rider. So therefore, my lord, I cannot,
Completely absolve your
speaking for
responsibility.
withdrawal, that could be done. my lord.
It is submitted that the 50% of the amount is deposited on 3/10/2023. 50% amount be IA number 1 of 24 is filed, seeking withdrawal of the amount by the claimant. Considering accordingly, I number 1 is allowed and the respondent is permitted, the claimant is permitted to withdraw the amount. Admit, post for final hearing, call for the TCR.
One more appeal, madam, filed by the owner, owner of the two-wheeler, in MFA 6818.
Post along with so and so, which is filed with the owner. Yes, next 19.
Cell number 19.
Respondent number 2,
No representation. Post for dismissal tomorrow. Yes, 20.
Published.
Cell number 20.
What is this maintainability?
Regarding a maintenance, I have filed a revision petition challenging the order of the section 7 and 25 passed in the Guardians and Warship Act. But instead of filing an appeal, I would have filed an appeal.
What is the order? Let's see.
Order. The final
It's a
order.
final order.
Final order.
Then you have to file an MFA.
Yeah, file MFA.
The
Liberty may be
petitioner,
given.
the petition is, the present RPFC is filed, agreed with the orders passed in GNWC number 197 of 2017, dated 29th October 2024. What were you doing till 18/7/2025 when an order is passed
No,
on
Lordship,
29th
No,
October?
it was an expert or law, expert, I filed an wakala.
29th
Thereafter,
October
I didn't came to know it was an expert
2024.
order.
The office has raised the objection with regard to the maintainability. The office objection with regard to the maintainability is sustained. The petition, the RPFC is not maintainable. Petitioner has to file an appeal accordingly. The petition is dismissed. The petition is dismissed as not maintainable. And the petitioner is at liberty to file an appropriate petition within 1 week.
Cell number 21.
So it is left to the court to decide about the limitation.
Please, madam.
Cell number 21. Premna Senti. Withdrawal.
Give that. The memo is filed stating that MC number 146 of 2020 pending on the file of the Family Court Mysore is disposed of by order dated 28/1/2022 and nothing remains for consideration this petition accordingly memo is taken on record. Dismissed. Next 22.
Cell number 22.
Appeal for petition, my lord, I will verify the address of third respondent, my lord, I will take steps within 2 days.
What happened? Why can't you take a notice on the counsel for the respondent when
My
something
lord,
is pending?
R1 and R2, the same counsel is appearing here. So for R1 to R3, the same counsel represent before the trial court.
Where is the counsel?
Ravi Shankar K.
I will verify and I will inform the other side, my lord, to engage advocate.
No, instead of doing all this, a 2023 matter, take notice on the counsel for R3 before the trial court.
Yes, I will serve.
And counsel for the petitioner shall take out hand summons on the counsel appearing for the R3 before the trial court and shall file a memo to that effect by 13th of August or else the writ petition shall stand dismissed. Yes, 23.
My lord, or else I will file a memo for dispensation to third respondent for the reason that no maintenance is ordered to third respondent.
Then write it and give.
So I will write it. Right now.
The memo, next, a memo is filed seeking dispensation of notice to R3. Memo is taken on record. Notice to R3 is dispensed with. It's not the
Interim-
first order.
Yes,
Yes, next.
interim order may can be extended.
You will hear it then.
Cell number 23. R Muralidharan.
Let it be. My lord, main petition is coming next week for final argument.
That is not a ground. How is it concerned? Then main petition will be decided on a different aspect. Give the file 22.
22.
Where is the impugned order?
Impugned order, my lord, if you start from page number 42. 48, sir.
How much is granted? 5,000.
5,000 to the second respondent, for first and third respondent.
5,000 interim maintenance of 5,000 to
To
the
the third-
petitioner number 1
Yes.
and 2. What does it mean? It
my
is
lord-
each or 5,000 to both of them?
My lord, for the reason is, my lord, the petitioner is having, this petitioner is having only one ancestral property.
No, I'm asking you, is it 5,000 each or 5,000 for 2 and 3?
There is no clarity, my lord, I
But
think.
it appears that it is 5,000 per month to the petition number 1
From
and
the
2.
date of application pending disposal of this petition.
Hmm.
There is no clarity whether for each.
So in the earlier paragraph, how it is, let's see.
My lord, it was start from
Considering the present
para
day's
number
cost of living escalation.
48,
and
para number
that
27.
awarding interim maintenance of 5,000 to the petition number 1 would meet the ends of justice to pay the much amount. Hmm. What is your 2 and 3 are the children?
2 and 3 are the.
1 is the wife.
My lord, 2 is studying MBBS in Russia. The petitioner has sold the ancestral property and sent the amount, given the amount to the second respondent for her admission to the MBBS in Russia.
Heard the learned counsel for the petition in part, no representation by the respondent. List this matter tomorrow, part heard. Yes, next.
Cell number 23.
23, my lord.
My lords,
I'm
I appear
appearing
for
for the
the
petitioner.
respondent, my lords. Filing the statement of objections, I'll be filing it in the counter, my lords.
May make one
Statement of
thing.
objections.
Tomorrow I am having into this.
Day after tomorrow. Yes.
My lord, I am for the petitioner. Your lordship gave her time for about more than 2 hearings for filing objections. More than 3 hearings have passed. And this is connected with between the same party. The respondent has filed the MFA 114 of 2020. And I have also filed a cross objection, MFA 2642 of 2022. Substantial justice will be between the same parties. She had filed a case for restitution of conjugal right, which was rejected, and she has filed an appeal. I filed a case for divorce, and that is rejected, and I have also filed an appeal.
What is this WP?
This is only for alimony payment. I have given bank documents.
Where is the impugned order page number?
My lord. I was
Which page is the order?
I have, if your lordship sees, the payments are
Really?
evidenced by bank documents actually.
No, Mr. Counsel, where is the impugned order? That's what I'm
Yes.
asking.
It's from 98 onwards, my lord.
Let's see.
I've made payments up to date.
Let me look at the impugned order.
Yes, my lord.
Then we'll see what is wrong with the order. Then you can make your submissions. 98, there is no 98 page number. What is the impugned order date?
Impugned order, it's apparently an ex parte order. Though I have filed my full statement of objection and all, your lordship will see in page 33.
Passed so and so, directing the abatement of criminal miscellaneous lodged on 18/9/2020 and the cancellation of fine, levy and non-bailable warrant. What is this prayer?
In fact, my lord, I have filed a very detailed, this is a case I have respectfully submitted your lordship. The wife wants one maintenance under section 125 CRPC, another maintenance under Hindu Marriage Act, and the third compensation under the Domestic Violence Act. All 3 cases are pending. And interim alimony was ordered at the rate of 10,000 rupees for my son as well as for the respondent. I had been paying it up to date. Final alimony had been ordered. That also I had been paying it up to date. And I had been paying the school fee. And everything is through bank channels, my lord, and I have produced the documents also.
Please understand, there should be an order which has to be interfered by this court. Or you seek a mandamus for any disposal of the matter.
Yes, my lord.
What is the order impugned in this?
Your lordship will take page 34 of my typeset.
Yes. No, yes.
And 23 and 34.
What is wrong with this order?
My lord, if your lordship sees, there are two orders. That is, orders on memo of calculation 26.
Yes.
The operative part begins at 27. Peruse the judgment in MC 4542 coming with criminal miscellaneous 521 of 2025. Both were taken up together and common orders were passed. As per the final orders in MC 4543 filed by the respondent herein for dissolution of marriage came to be dismissed, and counterclaim of the respondent wife for relief of restitution of conjugal right is also dismissed. On the other hand, criminal miscellaneous is allowed in part and petitioner is entitled for a monthly maintenance of rupees 20,000 from the date of petition till her lifetime or till her remarriage, and petitioner too is entitled for monthly maintenance of rupees 20,000 from the date of petition till he attains the age of majority. So the petitioner has calculated the arrears of maintenance from the date of filing the petition, that is 7/9/2025 to 19/2/1925. Further, the petitioner has also mentioned that the respondent on one occasion has paid a sum of rupees 4,40,000, total once calculated at 48 months. At the rate of 40,000 plus 48 months will be. On the contrary, the respondent has taken the contention in his objection statement that he has paid a sum of rupees 20,000 for 25 months in respect of the interim maintenance order dated 10/9/2015 passed in MC 4542 of 2013. So it is the contention of the petitioner that is in no way connected with the orders in maintenance. Interim maintenance is being paid in the main divorce petition quite regularly. Final maintenance is ordered, that also I have paid including the arrears. So at this point of time, she is saying, you have paid one maintenance in the main case, pay another maintenance in the criminal miscellaneous petition. And that is against the order of the Supreme Court in that.
No, please don't go to all that. You are
Yes.
questioning an order
Yes.
where FLW is issued. What is wrong in issuing the FLW? If a particular, no, there are 3 orders of maintenance. You
Yes.
have to question those orders. When the order is there, execution you cannot question.
Yes, my lord.
So what is wrong with the execution that I'm not able to
My lord, my
understand?
respectful submission is, once an MC case is filed and maintenance are awarded in that MC case, Section 125 CRPC is for avoiding destitution and stagnancy among women.
Have you questioned that order?
Yes, my lord.
Have you questioned that order?
I have paid that.
Have you questioned that order?
Yes, this is it. This is it.
You have not questioned that order.
I have questioned that order. 2 orders or 2 MFAs are pending. I have also filed an MFA. She has also filed an MFA. The orders have been questioned, my lord.
That's not, I'm not talking about the final order.
Yes.
You say that under 125 CRPC, she is not entitled for maintenance. Where is 125 CRPC order? Where did you question it?
125 CRPC is disposed along with MC 4542, my lord.
Correct.
I have also questioned that order.
You have to question it that order not in MFA. 125 CRPC order has to be
No,
questioned.
my lord, this,
by finding
both
the-
are taken up together. Well,
Maybe.
my respectful submission, my lord, is that one maintenance under CRPC,
We will not decide.
they have not even filed a statement of
But we will
objection, my
not
lord.
decide in the execution.
All through they concealed the fact that they have received the money, my lord.
I'm not convinced.
They have not even filed a statement of objection, my
Not
lord.
statement of objections. How can you raise all these grounds in an execution petition that she is not entitled for maintenance? I'm paying maintenance somewhere.
No, my lord, if your lordship sees the money, your lordship also asked me to file an affidavit. In that affidavit, I have stated very, very clearly, my lord, so far, if your lordship sees the affidavit,
Let the trial court decide all this. I cannot calculate, I cannot decide. If you have paid the money, the warrant.
let them state it, my lord, that I have not paid the money.
Not them, let the trial court decide
I
all
have paid, my lord, total sum of 43,63,875.
Well, then what is due?
Yes.
What is due?
Huh?
What amount is due?
Nothing. It is for them to state. Your lordship directed them in the last hearing to state clearly how much is due from me. They haven't filed that counter yet, my lord. Your lordship peruse your previous orders.
Come to page 36.
My lord,
Page number 36.
page number of my payments, my lord, proof of payments,
Page 36 of your petitions.
page 36.
This is the impugned order.
Yes.
This writ petition.
Yes.
So why should this court interfere with this order? What is wrong with the order on the face of it?
My lord, this is simply for the reason that MC case, an order of maintenance is passed depending on the rights, liabilities of the respective
Where
parties.
is the application filed by you before the court?
Yes.
Saying that the court cannot execute the decree.
Yes.
This cannot be executed. Where is that petition? You don't do anything.
No, my lord, I have filed my statement of objection, my lord. And I have stated very clearly in the trial court that I have paid the money, my
Yes,
lord.
we will see this. We'll see this next month. List the matter on 9th of September.
If they have filed an objection, I must have a copy, my lord.
Yes, serve the copy.
Please, my lord.
Yes, next.
Cell number 24. Srinivas DC, awaiting service of notice.
Non-taking of hand summons by the council.
My lords, I didn't hear the order, my lord, that day.
I think this you have submitted on the last occasion also.
No, my
Let
lord,
me look at
I
it.
have taken notice. I have taken notice.
Show it. Show that order. I remember you are informing the court on the last occasion also, same thing.
No,
No?
my lords, no.
1 minute.
I have taken notice as of now, my lords, but I'll collect the hand summons today itself.
As per the order dated 17/7/2025, and I said by 29/7/2025 it is not filed, it will be dismissed.
My lords, I have taken notice. I'll file the acknowledgement.
Counsel for the petitioner shall take out hand summons
Yes.
on the counsel for the respondent, and memo shall be filed by 11th of August, or else the writ petition shall stand dismissed.
Much obliged.
Cell number 25.
I think you heard it now, right?
Yes, yes. Yes, ma'am.
25. Ilasha Arol Norona.
Memo of withdrawal. The memo is filed stating that the dispute between the parties is amicably settled in MC number 910 of 2024 dated 3/6/2025, and a permanent alimony of rupees 10 lakhs is paid with the petitioner. Considering the same, the memo is taken on record and the petition is dismissed as withdrawn. Yes, next.
Cell number 26. 26 serial number.
My lord,
Yes,
I have
Bhuvan.
taken steps to respondent, my lord. Respondent counsel has recently given NOC to the respondents, my lord, who is appearing in the trial court, my lord. He has given NOC
Pay
to
the
the respondent.
process.
My lord, already paid, my lord.
When did you pay?
I have paid on 24th July, my lord.
The council submits that the process is paid on 24th. Registry is directed to issue notice.
Please.
Yes.
Cell number 27. 27.
Officers raise objection on the,
There must be an order on the last occasion. Give it.
RB Sadashiv.
and they have to file an affidavit also as per that.
Office objection shall be complied with within a week. List this matter extended till the next date of hearing. In spite of an order passed by the court on 15/7/2025, the respondent has not complied with the objections raised by the office on a statement of objection filed by R1. The list is finally, list the matter day after tomorrow. By day after tomorrow, if this objection is not complied with, the court will not consider, the court will consider as the objections are not filed and will consider the main petition. Interim order is there.
Yes, please.
Is extended till next date of hearing. Yes, 28.
Cell number 28.
Lordship,
Rajat.
day mail call. Day to tomorrow.
Devendra
Monday, if I
Bellari.
kindly have it.
Monday.
Monday, please.
Yes.
Correspondent, 28, serial number.
Huh?
48.
Serial number 28, my lords. This, my lordships, kindly recollect matter where Supreme Court directed for.
That's true. Why that's non-compliance of office
They
objection?
had to comply.
Correct. Small office objection tomorrow. We can't complain.
There's only one submission.
The vacate stay petition is filed and the office has raised certain objections. Those objections shall be complied with by tomorrow. If not, the vacate stay petition will not be considered. And the court will, the same, the list is matter day after tomorrow.
There's only one submission in this case. Supreme Court, my lords, we have filed an application.
It's the day after tomorrow. Can it
But
wait?
it must be heard after September because the issue out of which I have obtained a stay itself is, my lords, pending before the Honorable Supreme Court. This is the order, my lords, where.
They have preferred an order.
No, we have preferred an order, the petition, my lords, seeking recall of the order which directed us to pay them maintenance as per the High Court's order.
Your question here also.
This order is, my lords, also pending consideration before the Honorable Supreme Court. My lords, what happened in this case? Supreme Court directed us to pay.
No, who has filed the, who has carried the matter to the Supreme Court against the interim order?
No, not against this interim order.
Then?
My lords, the Supreme Court ordered for a sum of maintenance.
I
15,000
remember
rupees.
that.
Yes,
Why
my lords.
not this court independently deal with this?
It's because the matter itself is pending. That order itself is, my lords, we filed an application seeking recall of that order. So pursuant to that order, my lords.
Then why did you question it again here?
No, my lords, because I have directed to pay as per the High Court's order, only seeking clarification, not recall. Clarification seeking how much is the amount that I am liable to pay to them. And my lords had directed me to bear the educational expenses. I have borne it for this year.
No, somehow I'm not able to understand that connection.
Please, my lords.
An order.
Yes, my lords.
Which is impugned before this court and an interim order is passed.
Is granted. Is granted.
And what is the connection of this order with the Supreme Court order? If there is a connection, why should this order pass any order, any interim order in between?
No, my lords. The order passed by this honorable court is to, my lords, stay the further proceedings as far as the execution proceedings are concerned. Now, those execution proceedings, my lords, would bear significance from the Supreme Court's order. There also they have obtained notice.
In the meanwhile, the trial court shall proceed to decide the matter in terms of the order of this court dated 23/4/20.
That also they have not completed. The 2 months order which the Supreme Court passed in 23rd April. Till date, my lords, the MC proceedings are going on at their request. There they have sought time to, my lords, advance their final arguments.
Something is like, we'll hear it on Monday. Let me understand it on the fact.
Obliged.
List the matter day after tomorrow.
Obliged. The interim order may be extended.
Interim order earlier granted is extended.
Obliged.
Cell number 29. 29. Dipesh Swami BC.
What is this IA 1 of 25 recalling the order 24/7?
59 days delay condone.
No. Recalling order is there. IA 1 of 25. Oh, no. This is 29. Yes.
29.
How many days? 59 days.
59 days.
It's sued for R2. IA number 1 of 22 is filed to condone the delay of 59 days for the reasons stated. Delay is condoned. Admit, post for final hearing, call for the TCR. This next matter.
Cell number 30.
What is this recalling the order dated?
Maltesh.
The appeal was dismissed on the ground that, non-compliance of office objection. Only, statutory deposit of, 25,000, there is a delay in, deposit. That was deposited already.
Where is this order dated? 24/7?
24/7, 24/7/2023.
That order was passed.
Yes, Lord.
Subject to the condition that applicant shall comply with the office objections regarding that within a period of 2 weeks. And if the applicant do not comply with the office objections, the appeal as well as IA stand dismissed.
Yes, Lord. It's complied, my lord. Hence, my lord, I filed the application to recall them, my lord.
But thus, as per the material available on record, the appeal was dismissed on 5/4/2024 for non-compliance of the conditional order. However, IA number 1 of 25 is filed seeking the court to recall the dismissal order dated 24/7/2023. The appellant to clarify in this regard.
Yes, I clarified, my lord. There is no any order on, 5/4/2023. There is no any order, my lord. It is signature. There is a signature, my lord. In the below the signature, the date is mentioned. My lord, I clarified in, my lord, I clarified memo is also filed. There is a mistake.
The IA number 1 of 25 is filed to recall the order dated 24/7/2023. On the day a conditional order was passed by the court, and as the same was not complied with, the same was dismissed and counsel submits that now he has complied with the order dated 24/7/2023. Accordingly, I number 1 of 25 is allowed, and the order dated 24/7/2023 is recorded. Then there is a delay of 650 days. Which is who are the respondents?
No, respondent, my lord, is the, my lord, the claimant. My lord, I am the, my lord, owner of the bus. My lord, I place it ex parte. Though, my lord, insurance is
Yes,
there.
notice to the respondent.
Cell
I
number
will pay the
30.
process, then again, that is one more.
No, my lord, I will pay the.
The process shall be paid within 2 days, and if the process is not paid within 2 days, the appeal shall stand dismissed. Notice to the respondent.
Please.
Cell number 31.
My lordship, in this case, I have filed a memo on 23/7
I had got
informing the court how the petitioner out here.
Oh, you are
has-
the petitioner or he is the petitioner?
In the RPFC, he's the petitioner. But
Then
the
he has
memo-
to argue.
Right, I'm not arguing the matter. I have filed a memo bringing to the notice of this honorable court how he is trying to circumvent and obstruct the process of law. Before this
In
honorable court.
RPFC, I am only concerned with the impugned order. We
Agree,
will
my
not go
lordship.
into any other issues.
Agree, my lordship.
Yes.
This honorable court had passed an order when they filed an application for stay. An order from this honorable court was passed saying, asking him to pay 50% of the arrears. This particular order was taken to the
Let me
Supreme
make my
Court.
submissions, my lord. This would not be fair for her
That's
to
a whole
start.
difficulty with the party in person, because there are some niceties, there are some procedures in the court which has to be followed. Yes.
Very sorry, my lordship.
Argue.
Please, ma'am.
Yes.
This is the,
Yes.
Lords had passed an order on 11/6/2025, not after hearing me for some time.
On date of order.
11/6/2025, Lord.
We'll take it in the afternoon. There are so many other matters. If I take up this matter, it's gone. I'll take, after passovers, I'll take up this matter. Yes, next. Call the next matter.
Cell number 32.
We'll take it up later.
Adjourned.
Good afternoon.
Cell number 33. Cell number 33.
Yes.
Girish B. Baldare.
Lord, 38 also is between
Yes,
us.
that also will take up.
Very well, great.
Yes.
Much obliged.
Comply the interim order, my lordship, deposited
3. There's a delay of 451 days. Non-filing for acknowledged for having maintenance amount. You have paid entire amount.
Paid, ma'am.
Entire amount is paid.
Third.
Land counsel, the petitioner submits that the interim order is complied with, and I filed a memo to that effect. Land counsel, the respondent submits that she'll get instructions in this regard. What do you say about the delay? Objection. I number 1 of 24 is filed to condone the delay of so and so. For the reasons stated, no objections are filed. For the reasons stated, the delay is condoned. List this matter on 19th of August.
Any early date, my lordship? Any early date? Next week.
I'll be hearing it finally. She's also there. It can be done. 19th August, today, where are we now?
Your Lordship,
Yes,
may I
next.
make one submission? In serial number 77, I'm appearing for the petitioner. It will be taken up on another date. Some
Use
inconvenience.
the mic, ma'am.
Inconvenience today, Your Lordship.
You will be mentioning about your
I'm-
case.
I'm sorry.
At 77. Sorry. That I can't consider. Yes, next.
Cell number 34. Cell number 34.
This case I
Vinod
am for the
Gowda.
petitioner. This is a
Mustaq
wife's
Ahmad.
petition for enhancement. The trial court has,
No representation for the respondents. I number 1 of 24 is filed to condone the delay of 207 days. Reasons state, no objections are filed. For the reasons stated, delay is condoned. List this matter for hearing on any lower court record is required or not required? Not required. List this matter on 20th of August. That day we'll hear and pass final orders.
35.
This case,
Nehru Yemen.
I am for petition, please.
Hmm.
The,
Respondent, my lord.
They filed the petition for withdrawal of the amount.
yeah, that's what last occasion also I objected, Your Honor. The ex parte order has been passed. So she is living with the adultery. And apart from that, all the 2 children are with me. And that paramour of the respondent against,
Are you ready to argue?
matter on short date may be given
Against-
and it may be.
I think that's on the last occasion when you, what is the
No,
order
no,
on the
this
last
is the
occasion?
first time they are appearing
Actually,
before your
the
lordship.
file
The
is-
learned counsel for the petition is present, no representation on behalf
My
of the respondent. If there is no representation on behalf of the respondent on 29/7/2025, matter will be dismissed on the merit.
In the last hearing, I was engaged in another court. Happened, actually.
This
my
is
lord-
matter on,
My lord,
on
amount
14th
may
of
be-
August, on 14th of August. Yes, next.
Cell number 36, David Ramesh. Udita
For
Ramesh.
petitioner in the first matter, my lord,
30?
six,
Six,
my lord. Appear for petitioner, my lord.
Hmm.
I'll have to file statement of objection for the additional documents which they are filing.
What additional documents before this
This is
court?
FSL report, my lords, before the trial court. These are the,
13th. Hmm.
my lords, these documents show that the father had made oral remarks against the
No, why should
wife
we?
and the
No, no,
children.
no, no. There is for filing, why I'm not, what I'm not able to understand is, no, this court is looking at an impugned order. Whatever are the document that are filed, that you have to file before this court. No new documents.
My lords, what has happened in the meantime of the
No, the basis for
matter
the
being
court to
pending.
decide a particular application is basing on the material then.
It's on the custody, my lords, that the matter has been.
We will see. No documents, no objections. We will see the matter. What is the wrong with the order of the court? Where is the order? You appear for the father.
Appear for petitioner, my lord, husband.
Page number?
Lord, order is at, my lord, page 99, annexure J2. Passed on IA number 10, my lord.
1
Initially-
minute.
Initially, my lord, as per IA number 4, I was granted visitation rights. Number 10, my lord, I've asked for the restoration of the same, my lord, which was.
IA number 10 filed under section 151 CPC is rejected.
Please,
That
my
is
lord.
filed by the father seeking visitation is rejected. Come to the reasoning part. Come to paragraph number 13.
Please, my lord.
What is the age of the minor?
Age of the minor is 7 years now, my lord, 6 years, 6 to 7 years. My lords, in the
Lord, they say, my lord, the child is
Read
suffering.
it, read the order. I have to know what are the facts of the case.
Please, my lord. Lord, it is relevant to note here that even this court personally interacted with the minor in the chamber on 24/6/2023. Even at the time also, this court observed that minor was not comfortable with the presence of his father in the chamber. The observation made by the court is as under. Though several attempts has been made to allow the respondent to participate in the said interaction with my chamber, but the minor did not cooperate for the same, as he had started crying when it asked for whether his father can be permitted to participate in the interaction. But after considering both the reports of Dr. Ravish Tunga and also observation made by this court, dated 24/6/23, in my opinion, absolutely there is no reason or grounds to set aside the order dated 7/2/2024. Lord, basically, the order, my lord, has passed relying upon two reports, my lord.
Why you have not filed the JNWC? But from when the parties are leaving separately?
Uh, Earlier, my lord,
my lords, JNWC was filed, my lords, that came to be dismissed for no jurisdiction. After that, there was no subsequent JNWC was filed by the father. JNWC 1 of 2023. Now, my lords, the reports, everything are against them. Now they come up again with one more application to counsel the child in Niman's, my lords, after 3 rounds of counseling. Even this, in fact, this court also, my lords, had in chamber this one, and it is recorded that the custody could not be done because of there is no
Obviously,
settlement
my lord.
couldn't be arranged.
Mhm.
There's no settlement between the parties couldn't be arranged for the custody of the child, visitation rights of the child. This court recorded it on.
However, my lord, when the matter was taken up in chambers,
Let him complete what he's saying.
please, my lord.
This court, my lords, are order dated
Why is he behaving like that?
17/1/2025, my lords.
Why is the boy behaving like that?
My lords, the boy has seen that he shouldn't see that what the father has done to mother in the boy. My lords, the counseling reports will clearly disclose that the boy is not ready to meet the father at this moment. In fact, the mother tried to send the boy for visitation rights.
So
But
what
the
has
boy-
to be done? We cannot leave it there. If you leave it there, it will precipitate more. He shouldn't be living with those kind of emotions. Something has to be done.
The boy
What
has
is
to
being
go,
done now?
For 2 years of counseling is what the Revishtunga report says.
So when that counseling has started?
Counseling has started in the,
And what is the outcome of the counseling so far? Whether it's making any difference or not, or he remains to be the same where he started, all that we need to know.
that I'll seek instructions, my lords.
Where the mother is
Now
taking him for
what has-
counseling.
To the doctor, my lords, Revishtunga.
I know she'll take him to the doctor. Which doctor and where?
In Mangaluru, my lords.
In Mangalore.
Mangalore.
Then where is the report of the doctor?
Recently, there is no report. The report was submitted to the court.
No.
That was the
Court
initial
says that
investigation.
there is some difficulty. That problem needs to be addressed.
At this time, he can't meet the child. He can't meet the father. Is what.
That is one limb of the order. What is happening next? Forever it can't be like that.
Yes,
Because the
ma'am.
boy do not want to see the father, that forever he will not meet the father.
I'll seek instructions. What happened?
That has to be addressed. And please ask your client what is happening from the date of order till now, where she has taken him for counseling. What is the state of mind of the boy? Whether it is or like it is the counseling is making any difference to the boy or not, and what are the efforts made by the mother. Then counsel for the respondent mother shall get instructions about pursuant to the order dated, pursuant to the order impugned, what are the steps taken by the mother, and what is the latest report pertaining to the boy, and whether there is any change in his attitude towards father from the date of order till now. Basing on that, further orders will be passed when?
Maybe taken up on the 3rd week, my lords.
Why? Why you require
Mangalore,
that
ma'am.
much time? Mangalore, so what? Things come from, list the matter on 18th of August.
Much obliged.
Yes, next.
37. Akash.
For the petitioner, my lord, I apologize. I'm busy, my lord.
Yes.
I'm unwell for the day. Can it be
Yes.
have it tomorrow, my lord?
Tomorrow.
On Friday, it will be taken up, Lordship. On Friday.
Friday.
Then Lordship, 6,640 is the balance amount. Direction will be given to pay the.
Propose-
they have to pay the
out of
school fees on
proportion,
child.
my lord, I'll come
We'll
and-
do
You have to
all
pay the
that
school
if you
fees, Your
hear
Lordship.
him.
And the single parent.
My lord, I'll come down personally, my lord. I'll address my
Friday,
argument.
Friday,
Knowing
Friday.
it's out of proportion, my lord.
If you want tomorrow, he's ready. You want it on Friday.
Friday.
Tomorrow is ready.
Yes, Friday.
Tomorrow I'm ready,
Friday.
my lord. Well for the day.
Friday, Friday.
Grateful, man.
Cell number 38. 38 pass over along with.
Party in person.
Cell-
Where is he?
Cell number 39.
Huh?
38 is Manmohan.
Along with that, we'll take it up at 2:30.
Cell number 39.
For the petitioner in this case, Your Lordship,
Yes,
filing
yes.
a memo for not press, Your Lordship.
Yesterday's matter. A memo is filed stating that the petition has become infructuous and wants to withdraw. Accordingly, memo is taken on record and dismissed as withdrawn. Yes, 40?
Cell number 40. 40. Rangaramu.
Yes, ma'am. Here for the petition, my lord.
Yes.
This is arising out of the execution proceedings in the DV Act filed by me. It is rejected. Page number 36, my lord.
36.
36 is the order of the original suit. He is entitled half share in the property. Property measuring 20 by 30.
No, let's first look at the impugned order.
Impugned order next year, yeah, my lord.
IA number 5 filed by the JDR, protection of women from so-and-so is rejected. Issue delivery warrant in respect of a scheduled property of the DHR described in final decree on the file of the court. Decree holder shall not disturb the position and enjoyment of the JDR over B scheduled property demarcated in so-and-so. Yes, now let's go to this decree. What is the decree?
Please, ma'am.
What is the decree that you're seeking execution?
Decree is offshare in the property measuring 20 by 30.
Let us see the judgment and decree. Then it says about protection of women from domestic violence act.
I filed the application because of the reason he is owning separate property also. The husband is owning separate property. I also produced the photographs to show that it is there. Even otherwise also it is suggested, even there is also an order. In case if they want to sell the property, I am ready to somehow with great difficulties take the loan and purchase the property. The daughter is studying in the
we
PG.
better read the impugned order so that I'll be able to understand the facts.
Please, ma'am.
Yes. Read from this reasoning part.
Para 9, I may probably read my para 9, page 20.
So you are the JDR.
Please, ma'am.
Decree holder is the husband.
Please, ma'am. It is very clear from the above fact that IA scheduled property herein subject matter of the decree referred to herein above, and that the said house property both parties have half share, and the said half share of the parties have been identified and demarcated by the court commissioner, and now the only thing left out to deliver possession of these respective shares of the property. Herein contains that the execution petition shows that the decree holder claiming the delivery of possession of half share the suit property in annex schedule A property terms final decree. He is not claiming a right or share of the delivery of possession of the B schedule property allotted to JDR. So far, the court has not received any stay or order appeal intimating by the Honorable High Court of Karnataka regarding the decree passed by the court in the above OS number 57/2008 in FDP 1/2019. In fact, OS number 98/2022, the court passed the interim order in favor of the JDR herein from dispossessing from the property. The decree holder has not filed any objection to the said application. Yes, the said order was extended till further orders white so and so 3/1/2023. The learned counsel for the decree holder has submitted that since the decree holder executing the final decree in present proceedings by legally proceedings against the JDR, the interim order passed by the court in OS number 98/2000 will not come in the way of the issuing delivery warrant in favor of the decree holder in respect of the half share of the property. A scheduled property, he has further submitted that this court has already decided the right of the parties contention of the decree JDR demarcated the suit property and allotted the share A scheduled property in favor of the DHR. Hence, there is no legal impediment to issue the delivery warrant in favor of the decree holder. Per contra, the learned counsel of the JDR has submitted that a few ex parte temporary injunctions order passed by the court in respect of very same property OS number 98/2022 delivery warrant cannot be issued in favor of the decree holder. Now it is relevant to note that in the event of execution of the final decree FDP 1/2019 4/11/2022, the right of the JDR over B scheduled property referred to in the above final decree will not be affected. JDR could issue her relief in respect of the property that is B scheduled property in accordance with law. Herein, the JDR has not convinced that the legal right she has over the half share of the property, DHR in the suit property that is A scheduled property allotted to the share of the DHR. Hence, the contention have been negatived in OS number 57 and FDP proceeding 1/2019. Of course, the JDR contention that she has her daughter Dikshita are residing in the suit scheduled property,
Where is your petition in the EP?
Please,
Where is the EP? In the execution, where is your petition?
FDP is there, man. I will read.
Not FDP. It's not final decree proceedings.
That is at page number
Execution, in the
49.
execution.
Execution.
In this execution number 110 of 2022, where is your petition application?
It is there. I will read, man.
No, I've seen the order. Now I've seen the order. That's why I want to see that.
Please, man. At annexure J, page 79. Page 79, man.
17.
79, 79. Application under section 17, 19,
yes,
A and C of the Protection to Women from Domestic Violence Act 2005, read with section 150 of CPC and section 26 of the Protection to Women Property Mala. So
The competent court has granted a judgment and decree.
Please, ma'am.
Preliminary decree is passed stating
Please, ma'am.
that you are entitled for A scheduled property.
Please, ma'am.
For the B scheduled property, you are entitled for B and the decree holder is for A.
Please, ma'am.
Then a preliminary decree is passed, final decree is passed. You
Yes,
never
ma'am.
question that.
The
You are
final-
staying in, you are entitled for B scheduled property.
Yes,
You
ma'am.
can reside in B. Why should not A scheduled property be delivered to the decree holder? And you also filed a similar suit, both you and your daughter, another suit. In that there are no orders are passed.
No, my lord, in the FDP proceedings is final MFA before this honorable court. In this honorable court, the respondent, the decree holder herein has undertaken they will not precipitate the matter. That's also pending before this honorable court, before the division bench, MFA. Man. In the MFA, it is already an interim order or the court has directed him not to precipitate the matter.
Then he will not precipitate. But as far as this petition is concerned, what is wrong with the order? We have to decide. There is absolutely nothing wrong with the order.
Because of the reason by humanitarian ground, the husband is having a separate property also. He is also living with some other person, number one. Number two, it's very small property. It cannot be divisible because.
But you have not stated any of these grounds in the final decree proceedings. In the final decree proceedings, without considering your objections, an order is passed. You do not question either preliminary or the final decree proceedings. And how are you entitled? And then again, you file a separate suit. And how the execution be stopped now?
Decree and also those things are challenged in the MFA. It is also pending.
Can't be. We can't have the decree holder having a decree in his favor, and if he's not able to enjoy the fruits of the decree, then the procedure itself it can't be a paper decree. Please come.
May I request, my lord? I will get the information from
Yes.
the other side and.
Get the information. If he has undertaken before the court, let him undertake, and he will not. But as far as this petition is concerned, we will pass orders.
kindly
This
call-
is matter.
Next week, ma'am.
At the request of non-counsel, the petitioner on 6th August, on the day final orders will be passed.
Till number 41.
Next week, ma'am.
Next week.
8, sir.
I am appealing for the petition in this case, my lord. The request will also kindly, this matter may be taken up 2:30, my lord.
2:30.
Public.
42.
42.
I appeal for petitioner, my lords. The primary reason to approach this honorable court is that the petitioner is not able to tolerate the harassment at the hands of the respondent.
Where is the impugned order?
My lords, there is an injunction which is passed by the trial court as well. My lords may kindly
Please come to your prayer. What is the prayer you're seeking?
to issue a writ of mandamus directing the trial court to dispose the
MC
matter
on the
in a
merits in a
time-bound
time-bound manner in 3 months, which we cannot do.
If I may have 2 minutes to convince the bench,
Yes.
my lords. The husband is a government employee and the respondent has filed innumerous complaints before 7 police station. There are 13 complaints which is lodged by her, and there are 2 out of which has resulted in FIR and 1 is quashed by this honorable court and 1 has resulted in the B report. And wife has also made complaints on the superior officer, if you, my lords may kindly look
No,
into
not
page
required.
number
I'll take the statements as you say on its face value. I don't have to look at it. You can tell the court, we'll take it for granted.
The injunction is granted, my lords, to restrain the respondents from approaching the superior office. And the only point at this point I would pray is that to dispose the petition in a time-bound manner.
But still, after hearing you for 2 minutes, still I can't pass the order. The present petition is filed, seeking a direction to the 5th Additional Family Court at Bangalore to consider and dispose of MC number 6052 of 2023 on merits in a time-bound manner within 3 months. Land counsel for the next paragraph. Land counsel for the petitioner submits that the wife is harassing the husband. Husband is a government employee. She has filed several cases, and also she has given complaint to the superior, and she has made his life miserable. Hence, there shall be a direction to the family court. The Honorable Apex Court, in several cases, the Honorable Apex Court has passed the order wherein the High Court in each and every case cannot direct the family, the courts, the district courts or the other courts to dispose of the matters in a time-bound manner unless and until that may cause that it is a case which warrants such an order, as it is for the trial court judges to manage their board, and this court cannot pass any orders. Particularly when it comes to the family courts at Bangalore, they're burdened with a lot of work, and several matters are pending. On the administrative side, the court had already passed orders directing them to dispose of matters only till 2019 and giving priority to only those matters, and no other matters shall be taken up. This case, as submitted by the Land Council, it is not such an exceptional case that this court has to pass orders where directing a matter of 2023 to be disposed of, as these are all the problems in every matrimonial matter. And in that view of the matter, this court do not find any reasons accordingly dismissed.
Number 43. Arun Govindraj.
Yes.
Petitioner, Your Ladyship, wife's petition for enhancement of an order of interim maintenance.
Yes,
the only
notice.
grievance at this stage, Your Ladyship, is a paltry sum of maintenance has been ordered on the
What
grounds
is the
that
respondents?
I'm not looking for any arrears at the moment. Educational expenses are being paid by the father. Is what
order,
he's-
no, it's parte order.
It's his own admission, the father's admission, and recorded in the order.
Let the party
Since
come.
the educational expenses are due
Hand summons.
to the council.
Shall file a memo to that effect. When can you file?
I'll do it in the coming week itself, Your Ladyship.
Shall
By Friday, I
file a
will file.
memo by 6th of August. If the memo is filed, list the matter immediately. Yes, next.
Grateful, Your Ladyship.
Number 44. Sachin BS.
Appear for the petitioner, my lords.
For the respondent wife, my lord.
Challenging the impugned order passed in an interim maintenance.
Oh, how much is granted? How much is granted?
Please, my lords, 8,000 is granted, my lords. Previously, my lords, in the DB proceedings, my lords, there is.
1 minute.
Please, my lords.
May I make a submission?
8,000. Yes.
Submitting that there is an interim order of 7,000 in the DV Act, and there is another order in 125. They have sought for a stay, my lord. Stay is granted. They have not paid even in DV Act, my lord. Totally, they have paid 13,000 so far, and even after.
How
after
can,
this-
when you are
after
not
this
paying
order,
the
my lord,
maintenance,
stay order,
how can you make such a submission before this court and seek in interim
My
order?
lords, as far as the instruction, my lords, the interim order was DB proceedings maintenance was granted subject to the modification. my
This
lords.
court has granted interim order on the ground that
My lords.
already an amount of rupees, how much? DV.
In 7,000. my lords.
7,000
Please,
is granted. Land counsel appearing for the respondent submits that the petitioner, neither he is paying
as on the
maintenance
date
in the
of
DB
writ,
Act,
my lord,
nor
1,19,000 was
nor Act, and he is coming up before this court and submitting that there is an order. Land counsel for the petitioner shall get instructions. When is the order passed in the DB case? When is and how much is the amount paid till now? This is matter on 7th of August.
obliged.
Obliged, my lords.
Yes, sir. Look at it, interim order is there extended. Yes, 46,
45,
45 is.
For petitioner, my lord. Lord,
Somebody was asking the adjournment in the morning?
yes, ma'am.
Yes, what is the order impugned?
Lord, the maintenance had been granted,
How much?
8,000.
Hmm.
Kindly refer page number 47.
12,000 I think is granted.
12,000 till the October, my lord.
Huh.
After that, from September 2022, she's entitled to intermittence of 8,000.
When is this order? 2025, when is this question? When is this order passed?
The order was passed on
16/9/2023.
16/9/2020.
That's question in 2025.
Yes, ma'am.
What is the stage of the suit? This
It's on
proceedings of
plaintiff
2019.
petitioner evidence, my lord. And the respondent is
No,
not.
why he has suddenly they realized to question it now?
In this matter, for petitioner, similar, since 2019, the matter is pending. After granting of
Which
interim
court
order.
is this? Which court is this?
Fourth additional family court.
Well, because it's a 2019 matter, we'll ask the MC to dispose of by December 15th. We'll not interfere with this interim order. You come, when did you
Yes,
come to the court?
My second prayer is, my lord, directed to trial court to expeditiously dispose.
That's what, December
Yes, ma'am.
15th, and we'll not interfere with this order.
Yes, yes, ma'am.
The present petition is filed, questioning the order passed in I number 3, whereby the court had granted maintenance to the wife. This order is dated 16/9.
2023.
It appears 22 or 23. 16/9, 16/9/23. The writ petition is filed on 11/4/2025. Though the learned counsel for the petitioner has argued on the merits of it, this court is not inclined to go into the merits of the matter, as an interim maintenance is questioned and nearly after 1.5 to 2 years. The learned counsel has made an alternative prayer to dispose or to seeking a direction to the family court to dispose of the matter. This MC is of the year 2019, and the same is pending before the
Fourth additional family court.
fourth additional judge family court, Bangalore. And already as there are specific directions issued to dispose of 2019 matters, there shall be a direction to the family court to dispose of this matter by 31st of December.
Cell number
Obliged,
46, Nandish
And
Patil.
this court has not interfere, is it made it clear that this court has not interfered with the order impugned?
Obliged.
Yes.
46, Nandish Patil for petitioner. Nandish Patil.
No representation, lists the matter on password. Yes, password.
Cell number 47, Gurudev I. Gachilmat.
It's appearing for the petitioner. Interim maintenance has been granted, my lords,
much?
for 20,000, my lords. I'm appearing
What
for
is
the
the income
petition.
of the husband?
My lords,
Income of the husband.
income, my lords, assets and liabilities we have produced, my lords, at annexure H.
How much? How much? You can tell the amount.
99,000 is the salary, my lords. In that 26,817 is the EMI which he is paying, my lords. 20,000 rent amount he is paying, my lords. Now 20,000 without considering this, my lords, the interim maintenance of 20,000.
Now let us consider.
And my submission is, my lord,
Now please tell the court after this reduction, what is the take home salary of yours?
my lords, I want to take your lordship to annexure H for a moment, my lords.
Page number.
Page number 67, my lords.
Yes.
The assets and liabilities of the husband, my lords. Here the income is mentioned at 99,036 is a page 67, 68, my lords. And he is also paying the EMI, my lords, at
So
page
let's say from 99,000, let's deduct 26,000.
my lords, 60,
What would be
page
the amount?
69. It is mentioned 26,817, my lords, and also the 6,000 is the expenses and 4,000 is a miscellaneous
That's what,
and medical expenses, my
No,
lords.
we will take it. We'll take it 26,000 plus 6,400, something you said.
And
So
also,
we'll take 40,000.
my lords, I want to take your lordship to bank statement, my lords,
Of whose bank statement?
of husband, my lords.
For what purpose?
Even he is paying the rent, my lords, of 20,000 rupees rent he is paying, my lords. So
EMI
these
for
things
what?
are- I want to take your lordship to
No, EMI for what he is paying 26,000.
a car loan, my lords.
Hmm.
Car loan, even before that he
So
used to.
26 plus 20, 46.
And other expenses, 6,000 is the medical expenses, my lords, other expenses
50.
4,000.
50.
My lords, why my submission, my lords, respondent wife was earlier also working, my lords. I have also produced the appointment order, my lords. And her
What
salary
is the
certificate
finding of the
also,
court on that?
her salary certificate also we have produced, my lords. I want
Then
to take
also
your
the
lordship
petitioner
to
submits that the court has
Annexure
failed to take
J.
into consideration the rent that is paid by the husband of an amount of rupees 20,000 and 26,000 and odd towards the EMI. And only considering the income at 99,000 has granted maintenance of 20,000. The husband, considering the same, they shall be stay of all further proceeding on the condition of 12,000 by 5th of every succeeding month, 12,000 arrears within 8 weeks. Either of it is not complied with the stay granted by this court's transvacator. Notice to the hand summons to the council appearing for the respondent by shall take hand summons and file a memo by 18th. By 18th, if the memo is not filed, even on that ground also, stay stands vacated. Yes, next.
My lords, they have filed a execution, my lords, now.
I said stay of all further proceedings.
336 of 2025, it should be mentioned, my lords, in the order. Criminal miscellaneous, 336 of 2020.
When the court says these proceedings are stayed, automatically the
May I
execution will
ask for
not go on. Yes, hand delivery. Yes. Yes, next.
I request for, it will be listed on 18th, my lords.
Which matter? Execution.
Memo
No, my
has
lords.
to be filed.
Memo has to be. Obliged.
After you get the time on the website, you read the order.
Obliged, my lords.
Yes. Next.
Cell number 48, Nagaraj S for petitioner.
Yes.
Prayer is for enhancement of interim maintenance that has been granted.
Will order notice?
Yes.
Notice. Next.
Cell number 49, Santappa.
Yes.
Interim maintenance granted by the trial court is.
How much?
Well, 10,000 is granted.
10,000?
Favor of respondent, 5,000 each, my lord. He's a painter, my lord.
No, 10,000 plus 5,000 each is 20,000.
5,000 each in favor of respondent number 1 and 2.
It comes to 10,000.
Please.
According to you, what is your income? As per the order, what is recorded?
My lord, operative portion is at page number 30, my lord.
13.
30. She is also working, my lord. She is working as a receptionist at.
Where is it recorded?
That, my lord, he taken a contention. At,
No, it's only contention. There should
contention,
be
my
some
lord.
evidence.
But my lord, she is working in some
The respondent
hospital.
is working as a driver come conductor in KSRTC.
But he was dismissed. Presently is dismissed. He is working as a painter, my lord. That order is also produced.
Why
at,
the driver
my
is
lord,
working as a painter?
Please, my lord, there is no other option, my lord. He is working as a painter. And that order is also
So,
produced at
what
Annexure
did you
C1.
say? You must have quantified what is your income. Whatever work you're doing, you should quantify.
15,000 he is earning, my lord. And out of that, my lord, he is residing along with his parents. Old aged parents. He is residing in.
Half of the amount. The land council submits that he is working as a painter and earning 15,000 and the court had granted 10,000, which is on the highest side. Accordingly, 5,000, 2,500 to the respondent 1 and 2,500 to the respondent 2. 5th of every succeeding month. Arrears within 8 weeks. Same hand summons like in the other case.
Correct.
Yes, next. 50.
Cell number 50,
I appear for petitioners.
Yes.
The wife and the child's petition, my lords, on the ground. Lords, the quantum of the maintenance and my lords.
You're seeking enhancement.
Enhancement 1 and my lords rejection of the maintenance to the wife and also from the date of application is what my lords.
Notice to the respondent. Next. Same. In this also you take hand summons.
Yes.
Same like in the other order. Yes, next.
51
Grateful.
disposed,
No
52,
dismissal for this because there is no interim order in this. No default clause. Yes, next.
51 disposed, 52, Sumangalaya Swami.
Yes.
Petitioner is the husband, my lord.
Mm.
He was working in a good company. But
What
at
is
that
the amount
moment,
that is granted?
They have awarded 10,000 to each of them.
How
And
much? 20,000.
30,000. In this case, my wife is working as a staff nurse in Kempegowda Medical Science College, and she is earning 60,000 rupees per
What
month.
is your salary?
I don't have any salary. I'm working as a driver of the taxi. I'm running taxi, that's all. As a personal, this one, in a small village. I am ready
It is
to pay
submitted
for
that
my
the wife
son, my
is,
lord.
wife is earning and this factor is not taken into consideration. Court had granted 30,000. It is submitted that it is difficult for the
For my son,
petitioner.
I am paying. Even now, for son and daughter, I am paying. My
How
lord.
much?
20,000 per month I am paying.
Then the same that you continue to pay.
No, my lord, daughter is already, she is 25 old and she has completed her
She's
medical
25.
education.
And what about the other daughter?
Only one son
It
and
is
one.
granted under which 125?
Pardon?
This is granted under 125 CRPC.
Maintenance.
125.
The daughter is major.
Major,
And
25
working.
years and she has studied medical and.
And what about the other one?
Son is minor. I am ready to pay for son. No problem.
The court had granted 10,000 each to the wife, to the daughter, and to the son. Then counsel for the petitioner submits that the wife is employed, she's working as a nurse. The daughter, she has completed medicine.
Yes, ma'am.
She has completed medicine, she's major. And the son is minor. It is submitted that as far as the minor is concerned, she's ready to, the husband is ready to pay the maintenance. And the other maintenance, apart from being excessive, they're not entitled for maintenance, considering the same, say 10,000 to he's a third petitioner, third respondent.
For son.
Son is third respondent.
Second, this one.
The son, as far as the son is concerned, the father shall pay an amount of rupees 10,000 and arrears also at that 10,000. Same like hand summons and all. Yes, next. We'll take up after lunch.
My turn.
One submission. Serial number 74. Yes, I have paid memo preparation.
All that I will not hear now. I have to look at the file then only.
ಹುಡುಗಿ ವಿಜಯಲಕ್ಷ್ಮಿನ ಬೋರ್ಡಲ್ಲಿ ಎಲ್ಲ ಕತೆ ನಮ್ಗೆ. ಎಲ್ಲ ಸಂಬಳ ಹಲೋ ಸರ್, ಇವರು ವಿಜಯಲಕ್ಷ್ಮಿ ಅವ್ರಿಗೆ ಈ ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ ಇಟ್ರೆ ಅದು 5 PM ಅಂತ ಇರುತ್ತೆ, ಅದೇನೋ ಆಲ್ಟರ್ ಮಾಡ್ಬೇಕಂತ. ನಮ್ಮ ಚೇಂಬರ್ PS ಗೆ ಒಂದು ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು ಕನ್ಫರ್ಮ್ ಮಾಡ್ಕೊಳಕ್ ಹೇಳಿ ಸರ್ ಎಷ್ಟು ಗಂಟೆಗೆ ಅಂತ ಕೇಳಿ. ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ ಇದೆಯಾ ಅಂತ ವಿಜಯಲಕ್ಷ್ಮಿ ಅವ್ರನ್ನ. ಹಾ ಹಲೋ, ಇನ್ ಚೇಂಬರ್ ಮ್ಯಾಟರ್ ಇದೆಯಪ್ಪ ನಾಳೆಗೆ ಇದ್ರೆ ಅವರು PS ನ ಒಂದು ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಕೊಡಿ ಎಷ್ಟು ಗಂಟೆಗೆ ಅಂತ. ಅವ್ರೇನೋ ಆಲ್ಟರ್ ಮಾಡ್ಬೇಕಂತೆ ಟೈಮಿಂಗ್ಸ್, ಅವ್ರನ್ನ ಕೇಳ್ಕೊಂಡ್ಬಿಡಿ ಫೋನ್ ಮಾಡ್ಬಿಟ್ಟು. ಅವ್ರು ಎಷ್ಟು ಗಂಟೆಗೆ ಹಾಕಕ್ಕೆ ಹೇಳ್ತಾರೆ ಅಷ್ಟು ಗಂಟೆಗೆ ಹಾಕಿ ಇವಾಗಲೇ ಕೇಳ್ಕೋಬೇಕು ನೀವು ಈಗಲೇ, ಯಾಕಂದ್ರೆ ಅವ್ರು ನನಗೆ ಕಾಲ್ ಮಾಡಿದ್ದಾರೆ. ಸೊ ದೇರ್ ಇಸ್ ನೋ ಸ್ಟಾಟಿಸ್ಟಿಕ್ಸ್ ವಿತ್ ದಟ್ ರಿಗಾರ್ಡ್, ನನ್ನ ಹತ್ರ ಏನು ಇಲ್ಲ. ಸೊ ಅದಕ್ಕೆ ಎಲ್ಲ ಕೇಳಿರ್ತಾರೆ, ಕೇಳಿ ನಮ್ಮ ಹತ್ರ ಒಂದು
the court holds that the petition averments and para clearly discloses the petitioner is MBA graduate. It's also evident from pleading as well as evident that she had a prominent place in various organizations like Times of India and Midday Multimedia, and right from the inception is self-made. This clearly establishes that petitioner is qualified lady having prominent placement earlier. Petitioner in her whole petition has made allegations of cruelty, greed, etc. But she has nowhere pleaded she is unable to maintain herself now. In fact, my lord, there are clear pleadings saying that the petitioner had to leave her job because the respondent was a resident of the US.
This order is of the year, the civil miscellaneous is
2000.
2012. RPFC 2014.
14, my lord.
What
Yes,
is happening from 2014 to 24 without the maintenance? The wife is surviving.
So, my lords, yes, my lords, I'm aware the question that is posed, my lords. The respondent was ex parte in all proceedings.
No, that I understand.
Yes, my lords. Even in fact, a considerable amount of time was spent in serving the respondent in these proceedings. Eventually, my lords, by even after airmail, finally, my lords, the honorable court permitted us to serve him by email, and thereafter the matter was yes, my
because
lords.
let's forget about what happened to the respondent.
Yes, my lords.
No, the court gives a finding that she was like was having a good placement, about her qualification and all. So right from whatever the circumstances that you are saying might have been there, have prevailed there in 2012-14. What is happening from 14 to 25?
Yes, my lords. My instructions are in the year 2014, my lords, the petitioner was around
What was the age in
36 years old, my lords, in 2014, my lords. She was dependent on her widowed mother. And my instructions are that on the basis of her father's saving, she has been surviving, my lords. She has
Why
not.
was she not working?
She was not able to get, because she had to go to US, my lord. She had resigned from her job here. She went to the US. Then she got to know that the respondent was already married in the US. It was only when she entered US at the US consulate she was informed. In fact, my lords, even divorce
plausible explanation.
No, my lords, she has produced records of the US court.
Yes, with the qualification, won't you get a job?
Lords,
maybe you may not be getting a job which fits your your qualification and all. Not that you can't get a job with that some job or the other.
Lords, my submission is that the reasoning of the trial court is against the established principle. The capability of the wife to earn should not be equated to unable to maintain herself. My lords, I'm supported by certain judgments. I'll place them before your lordship.
Yes, you
the trial court has only held that because I had a postgraduate degree, that I am capable of earning.
Even now I'll say, we'll take it little forward, say that even till now you didn't tell before the court. You have not filed anything before the court to show that what are the efforts made by you to get a job and why you were not successful.
Because I have pleaded in the petition that because of my age, because of the advanced age.
36.
Because at that point in time, I was not, because of the experience that would have required at that age, I could not get a job in Mysore. I have pleaded that, my lords. And my lords, be that as it may, the husband's responsibility.
Whatever judgments for your sake, I'll record it, give it.
Two 2008 to SEC 316, my lord, paragraph 6 and 8, my lord.
Yes.
The object of the maintenance proceedings is not to punish a person for his past neglect, but to prevent vagrancy by compelling those who can provide support to those who are unable to support themselves and who have a moral claim to support. The phrase unable to maintain herself in the instant case would mean that means available to the deserted wife while she was living with her husband, and would not take within itself the effort made by the wife after desertion to survive somehow. Section 125 CRPC is a measure of social justice and is specially enacted to protect women and children, and as noted by this court in so and so falls within constitutional sweep of Article 15(3) reinforced by Article 39. I'll skip those paragraphs. Paragraph 8. In an illustrative case where the wife was surviving by begging, it would not amount to her ability to maintain herself. It can also be not said that the wife has been capable of earning, but she was not making an effort to earn. Whether the deserted wife was unable to maintain herself has to be decided on the basis of the material placed. Whether the personal income of the wife is insufficient, she can claim maintenance under Section 125 CRPC. The test is whether the wife is in a position to maintain herself in the way she was used to in the place of her husband. Before the trial court, my lords, we had also produced the financial capability of the husband. He was earning in the US. There was a complete neglect. There are averments in the petition saying
What
that
happened to the MC?
divorce, when it was filed under section 18 and 19 of the Indian Divorce Act to be declared as a nullity because the husband had not disclosed that he was earlier married in the US and had obtained a divorce, which information the
What
petitioner
happened
got.
to that?
The divorce petition, it was granted, my lord. It was allowed. Even there, the husband was ex parte. In all proceedings, my lords, despite service, he has remained ex parte. And
When was the divorce granted?
divorce was granted in the year 2000 and 2014, my lords. I have placed the order of,
So, then what about you're a divorced wife?
yes, my lords.
No, this petition is filed in the status of a wife.
Yes, my lords. The petition for maintenance was filed alongside the petition for.
That's what I'm saying.
Yes, my lords. At the time
So,
of
14, you like in 2014, you became a divorced wife.
yes, my lords. Yes, ma'am.
Considerations are different from there and the next.
But even during the pendency, my lords, even the petition for divorce was filed with another relief for maintenance, which was rejected, and the petition under 125 was filed simultaneously. Even that came to be rejected, my lords.
Yes.
Only on the ground that I was holding a postgraduate degree, that I'm capable of earning, and therefore I cannot be. It cannot be held that I'm unable to maintain myself.
Yes.
I'm supported by one more judgment, my lords, which I would want to place before your lordship. 2014, 16 SEC 715. Paragraph 7 and 8, my lords.
Yes.
Paragraph 7. Inability to maintain herself is the precondition for grant of maintenance to the wife. The wife must positively aver and prove that she is unable to maintain herself. In addition to the fact that her husband has sufficient means to maintain her and that he has neglected to maintain her. In her evidence, the appellant wife has stated that only due to help of her retired parents and brother, she is unable to maintain herself and her daughter. Where the wife stated that she has great hardship in maintaining herself and the daughter, while her husband's economic condition is quite good, the wife would be entitled to maintenance. In the petition, my lords, there are clear averments saying that I am solely dependent on my widowed mother. My father's savings are the only source of money that is available for my mother and myself. Even when I had to travel to the US, my mother only had provided me funds. So the recording of the trial court that there are no pleadings on the face of it is against the records, my lords. And in my petition, my lords, now I have extracted those pleadings also. So the trial court simply says that there were no pleadings also. I have extracted all the pleadings which are suggestive and where I have specifically averred that I don't have any other source. I'm dependent on my widowed mother. I have also said that my husband it was his legal and moral responsibility to maintain me. My lords, he is enjoying, none of the proceedings he has participated. There is a decree of divorce. He's not complying with any orders, my lords. My respectful submission that
in that order,
sorry,
where in that divorce petition, where the maintenance application is dismissed, what happened to that?
Because in the final order, the maintenance was dismissed, and the 125.
What happened to that?
Well, we didn't challenge that because this was still ongoing. After that order was passed, this order came to be dismissed. This we have now challenged before this honorable court.
Yes, please go. Agreed with the orders passed in. See miscellaneous number 75 of 2012, 18th January 2015, whereby the court had rejected the application filed by the wife seeking maintenance. The wife is before this court. The petitioner herein has claimed maintenance of an amount of 1 lakh from the husband. It is her case that her marriage was solemnized on 17/4/2010, and the husband, by practicing fraud regarding his occupation, age, and concealing the fact of his earlier marriage, has got married and revealed that he had an interest in the property of the wife. Subsequently, she got the information that the husband was a divorcee, and this fact was concealed by the wife, while by the husband, and by concealing, he has obtained the consent of the wife for marriage. And it is also stated that after the marriage, brother of the husband, on behalf of the husband, demanded dowry of 2 lakh and thereafter received the same. After the wife had joined the company of the husband in USA, she was not provided with basic needs. There was absolutely no facility to lead a family life, and he did not provide groceries and other essential things to cook the food. He had ill-treated the wife and used to use abusive and unparliamentary words towards the wife. Further, the husband had also developed relationship with his divorced wife, and they used to exchange messages. It is stated that she was well placed and she was before marriage and she has resigned the job. The husband is drawing a salary of 4,000 US dollars and looking at the income of the husband and needs of the wife, she is entitled for monthly maintenance of rupees 1,000, 1 lakh in Indian currency. How many days, how many years of marriage loss?
2 years, my lord. 17 for 2010 was 17 for 2010 they got married. The petition for divorce was allowed on
You
7
filed this
1.
petition in 12 itself.
Sorry, my lord.
This petition is filed in 12 itself.
Yes, my lords. 2012, 2 years.
The husband remained expectant before the family court, and the court had passed the order rejecting the application of the wife. The court has discussed the scope of section 125 of CRPC, that if any person having sufficient means neglects or refuses to maintain his wife who is unable to maintain, then the maintenance shall be awarded looking at the status of the parties. But in the petition, the wife has nowhere insisted that she is unable to maintain herself, and the material pleading is missing. And the wife in her evidence also has simply stated that it's a duty, husband is duty bound to maintain her and has willfully neglected her and refused to take care of her. And now she's under the mercy of her mother. But absolutely no evidence was given by her to show that she's unable to maintain herself. Admittedly, she's an MBA graduate and she had earlier prominent placements. No, there is no hurdle for her to set a fresh placement looking at her qualification, and she could definitely get any placement. And it is also evident that she has not made any attempts and she has not pleaded and proved that she is unable to maintain herself. Hence, the court has felt that she is not entitled for maintenance. In those circumstances, the court was not inclined to go into the aspect of the husband's income and other things, and accordingly dismissed. Then counsel appearing for the petitioner wife submits that the wife is having sufficient income and it's a duty of the husband to maintain the wife. Further, it is submitted that the court ought to have considered the fact that as on the date the application is filed, the wife is not in a position to maintain herself and she is depending upon the parents. On that ground, the court ought to have granted the maintenance. The court cannot look at the capability of earning, but the court has to look at the status of the wife as on the day, and her basic needs at that point of time needs to be taken care of. She has relied on the judgment of the apex court in Sunita Kachwa and others versus Anil Kachwa, 2014, 16 SCC 715, paragraph number 7 and 8. She has also relied on extracted in Chaturbu versus Sita Bai, reported in 2008, 2 SCC 316. She has relied on paragraph number
6
and
8.
6 and 8, extracted. Relying on these judgments, then counsel
6, 7 and
submits
8.
that.
Sorry. 6, 7 and 8.
6, 7, 8. Relying on these judgments, when counsel submits that the court has failed to consider the scope of section 125 and the facts of the present case, it is submitted that the wife is entitled for maintenance. Then counsel also submits that in the year 2014, the petition that is filed by her, Sikhi, under the Special Marriage Act, seeking to declare the marriage as nullity came to be ordered, came to be decreed, and in that also her case for maintenance was rejected. And as this application is pending, she has not questioned the said proceedings. Expert, having heard the counsels on the said, there is the material on record. The C miscellaneous is filed in the year 2012, and along with that, MC was also filed. MC was dismissed, MC was allowed, granted, declaring the marriage nullity. And no, in this, notice the respondent is held sufficient by order dated so and so so and so. So having heard the counsel for the petitioner, presumptive nullity, declaring the marriage as nullity. In that also, the application that is filed by the wife seeking maintenance was dismissed. The submission that the wife is depending upon the parents and she is not able to maintain herself, when it is her own case that she's an MBA graduate, and earlier before the marriage she was holding good position, and admittedly there are no children in the wedlock. Even after the divorce in the year 2014, till now, what are the efforts made by the wife to secure a job is unknown. The court has rightly observed that the wife, with the said qualification and with the earlier experience, why she is not working and is not working is unknown. All the judgment that are relied on by the petitioner do not apply to the facts and circumstances of the case. No material is placed before the court. How the wife is able to succeed or able to live right from 2012 till 2025. Even till 2025, she has no, according to the petitioner, she has no job and she is not able to maintain herself. None of these submissions that merits consideration before this court, and the court, for family court, had rightly held and rightly dismissed the petition. This court finds no reasons to interfere. Accordingly dismissed.
Cell number 3, Anjunatha G for petitioner, Kashinath JD for Kavita respondent.
For the petitioner in this case.
Yes.
But we are challenging the impeachment order of the trial court under IA number 2.
Page number?
Page number 17. So maintenance of 20,000 was ordered by the trial court judge with a condition, my lord. I would like to draw your lordship's attention to paragraph number 9, last but 9th line. However, it is made clear that after the completion of her education, she can opt for a job, and under changed circumstances, the respondent is entitled to seek for the review of this order. So we have provided sufficient documents to this court to prove that she has completed a PhD. She's a PhD scholar.
Review of that order before whom?
Trial court.
Not before this court.
Yes, my lord.
You should have done it before the trial court.
Yes, my lord. So
you're not supposed to come before the court. How are you? You say that the court said that we can review the order.
Yes, ma'am.
Review the order before the very same court, which is passed.
Yeah, the matter is still pending adjudication at the lower court, and we have
go before the same court and tell the court what is the change circumstances.
Much obliged, ma'am. My lord, but again, I would like to bring to your lordship's kind attention that she has filed another 2 petitions, wherein in that one was for CRPC 125, and one more I have filed for divorce. So even in that, she has filed for the maintenance, and presently there are 3 maintenance orders which are running parallelly.
What is that? What are you paying in 125?
In 125, she had asked for 30,000 rupees, and the court has ordered 4,000 rupees. Then in RCR petition, which is this present order, so in that 50,000 was requested. The trial court had ordered for 20,000, and your lordships had granted a stay with a condition of paying 10,000 rupees, which till now he is paying. Then in one more petition where I had filed for divorce under MC 1742 of 2023, she had asked for 35,000, and the trial court has ordered for 5,000 rupees. So till date, we have complied with your lordship's order of paying 10,000 rupees on or before 5th of every month.
So she's getting 29,000. She has granted 29,000.
Yes.
But what is paid is 5 plus 4, 9, 9 plus 10. 19,000 is paid as of now.
No, we are paying 10,000, your lordship's orders.
It's order. What about that you said 125, 4,000, divorce 5,000?
The other two orders we are yet to comply, my lord. Because we had got the order copy in the month of April. So for that reason, we couldn't.
Then I'll make it sure that you pay that whatever the 5,000, 4,000, and in this 10,000, and let the trial and whatever material you have placed before the court will decide.
But there's one more submission to make. Till date, they have not given the 3 years bank statement. So even the bank statement, which was filed in your lordship's court.
That I'll record. Please come. The present writ petition is filed, agreed with orders passed in I number 2 in MC number 98 of 2023, dated 3rd April 2024, whereby the court had granted an amount of rupees 20,000 per month as made clear. Then counsel for the petitioner husband submits that the wife has initiated 125 proceedings. There an amount of rupees 4,000 is granted, and the wife had the husband has filed who filed RCR?
RCR was filed by the wife, the respondent.
Had filed the petition for restitution of conjugal rights. In that she has filed an IA seeking maintenance, and the court had granted 20,000. Husband has instituted the divorce proceedings. In that she filed an IA for maintenance, and the court has granted 5,000. It is submitted at before different forums. She has maintenance of 29,000. When this petition has come up before the court, considering the said submission, this court has directed the petitioner to pay an amount of rupees 10,000. Then counsel submits that the court in the order has passed a conditional order that if the wife, that it is made clear that after the completion of her education, she can opt for a job under changed circumstances, the husband is entitled to seek for review of the order. Now, as it is submitted that now she has completed the education, as such, the husband has come before this court seeking review of the order. And it is submitted that as per the order passed by this court, he is paying 10,000 per month. Then counsel appearing for the respondent wife submits that the court has granted him to seek review of the order before the very same court. On that ground, he cannot come before this court. It is submitted that while granting interim order, the court has observed with regard to the amounts that are granted in 125 proceedings and the divorce proceedings, that is 4,000 and 5,000. Those amounts are not paid by the husband. Only an amount of rupees 10,000 is paid. It is submitted that court has rightly granted 20,000 and there are no grounds to interfere. Next paragraph. Having heard so and so, so and so. It is undisputed fact that in 125 proceedings and the restitution of conjugal rights, the divorce petition, altogether an amount of rupees 29,000 is granted by the court. In that, according to the respondent, the husband is not paying 4,000 and 5,000 ordered in 125 and the divorce proceedings. But however, in the RCR, as per order passed by this court, he is paying 10,000. Then coming to the contention of the petitioner with regard to seeking a review of the order, that he has placed all the record material before this court to show that there are changed circumstances and the order has to be reviewed. The order has to be reviewed by the trial court but not by this court. The petitioner husband is at liberty to file an application before the trial court seeking review of the order, and both the parties shall file their respective statement of assets and liabilities within 1 month from the date of receipt of the copy of the order. As far as the maintenance pending this petition is concerned, the husband shall pay 10,000 as far as this petition is concerned, and he shall continue to pay 4,000 and 5,000 in the other petitions.
My lord, in humble submission, if they don't file 3 years bank statement, then this 10,000 can stand cancelled. Because 14 dates have passed by and they have not compelled with the
both the parties have to file their respective statement of assets and liabilities as per the law laid down by the apex court in Rashish versus Neha. If the wife fails to file the application, the court shall not consider the application, and the amount of maintenance that is granted in this procedure in these proceedings, that is by 10,000, which is reduced by this court, the husband need not pay.
Yeah, we have filed, my lord. Let it be taken on record. We have filed, my lord.
Petitioner, as per the judgment, fails to pay, file the statement of assets and liabilities, court need not consider the review petition. Yes, next.
Much obliged.
4, Dhanalakshmi, wife of petitioner, Karthik V.
Appearing on behalf of the petitioner, my lord. My lord, wife's petition for maintenance. My lord, the impugned order can be found at page number 19, annexure A. The MC was filed by the husband, my lord, for restitution of conjugal rights.
5,000 is granted.
5,000 is granted, my lord.
Who is before this court?
The wife is before this court. If I may directly invite my lord's attention to page 28, para 11. A little background, my lord. The petitioner and the respondent got married in 2018. They have 2 children from the wedlock. The first child was born on 12/6/2020, and the second child was the first child was born on 29/10/2018, and the second child was born 12/6/2020. Both these children are of very tender age, my lord. One is of the age 5, the other is of the age 7. The mother is taking care of both the children in her maternal home. If I may directly invite my lord's attention to page 28, para 11. Are my lords there?
Yes, sir.
I'll read para 11 minutes. A bare reading of the above provision connotes that husband, they're referring to section 24 here.
Yes, you read.
A bare reading of the above provision connotes that husband or wife can file an application for interim maintenance during the pendency of the petition filed under the said act. This provision is silent about the maintenance pendentillite of the minor children. Moreover, petitioner can very well avail the benefit of maintenance to the minor child under the similar provisions of the other acts. Therefore, this court is not inclined to grant any maintenance to the minor children of the petitioner and respondent. My lord, this question is no longer res integra. The Supreme Court, as well as several other high courts, have ruled upon the aspect as to whether the maintenance to the minor children is covered under section 24. With respect to this, if I may rely upon a judgment.
No, please complete reading the order, then we will.
Please. Moving further, your ladyship, it is their contention that the wife has completed her bachelor's in engineering. They have also contended that she is in a. They have also contended that she is working, but they have not provided any details as to where she is working, what are the details of her employment, and that has been.
Have you filed your statement of this liability?
We have. In that, I have showed myself as unemployed, which I am, and I have taken a loan from my father in order to maintain my 2 minor children. Up until this order was passed, the husband was not paying any maintenance whatsoever, neither for the wife nor for the 2 minor children. He was not even paying the school fees.
Why are you not working being a BE electrical engineering graduate?
It is of the fact, if I may invite the litigation's attention to when this application was filed. This application was filed in 2023. The second child that I referred to, who was born in 2020, was of a very tender age of 3. And I was essentially thrown out of the matrimonial home. And I have no support in order to take care of the toddlers, the 2 toddlers that I have. This is the reason I was not able to maintain a job. I am taking care of the children full time, and I am not being provided any support.
Heard the legal counsel for the petitioner. No representation for the respondent.
If I may just produce one judgment.
No, I'm convinced. Let's this matter tomorrow as parted.
One submission, my lords. I'm apologized, my lords. Previous matter in the serial number 3. One submission regarding the all contentions of the both parties.
Yes, all are open. How can the court
But
close your
observation may
contention?
be made, my lords, kindly.
All contentions are open with the parties to agitate. Yes, next.
Cell number 12.
Yes.
one request at Interim. And we take that to the top of the list. Because this matter is-
Hartford will come on the top of the list only. Yes, next. Yes. Yes. Where is the imperial order? Page number. I number is allowed in part to pay interim maintenance of 6,000 per each petition, that is 12,000. Yes. Who are the petitioners?
In that matter, those petitions are the parents.
Hmm.
And there is a son who not stays along with it.
No, the son is before this court.
Two but the daughters, married daughters, those who are being separated from the family for 23 years. A petition for maintenance is being launched. When the son is there,
The son is also a party. K. Umesh.
son is also
Shashikala KK.
what makes the daughters also.
How much the daughter has to pay now?
Because they have said 12,000 months.
No, daughter can inherit the property of the father, but she cannot pay the maintenance to them. It is given to him also. It is for son is also ordered to pay. Daughter is also ordered to pay. Why the discrimination? No, that's what I'm asking. Married women is not entitled to inherit the property of the parents. Right to also. No, you can only argue on the point that the wife has no source to, pay the maintenance to the father. That much you can show the court, not the other things from the order. Hmm. Yes.
What circumstances petition has been? How not this petition eliminated because but the suit for partition has been presented
By whom?
by the daughters. Annexure A is that, and you must see that the father and son laws are defendants and page 44. There are ancestral property.
Yes, what happened to the suit?
That's paid. That's paid. However, immediately after the onset of that month, there is when the matter is at the advanced stage, right? However, the 125 petition is filed at the commercial procedure.
Yes.
And if you worship it, just go. Paragraph 3 there. It states about not the civil dispute of the properties which he has.
Yes, that we take it that the pending that suit, this criminal miscellaneous is filed by the parents. Yes.
So that kind of issue lost. Just examine the feelings. Paragraph 3 there is moving.
So what is the relevancy of it? That's what I'm asking.
This is how
No, that's what I'm saying. We accepted that pending the suit, they came up with this. Yes.
Onwards, I am on the point once where only the presence of the son and not without his incapacity being disclosed that he is not incapacitated to maintain. So generally, should there be omnibus reward in case where the only daughter of law and human writing is quite true, the acceptable laws and the daughter also we have to maintain. Presence of a son who stays along with him, we are married for this, they are separated 25 years. How much this is a case where possibly not the maintenance of these things not is prospective in its nature even until use. Now, possibly to that extent.
Yes. That apart, we are not, this is not filed under the, uh, the family, this thing. It's filed under 125. No, only thing you can only convince me on one point. Whether the wife, the daughter has a capacity to pay or not is the only issue. That is like accepted. Daughter is married. After marriage only she has filed the petition for the partition. Yes. That I even, I've noted on your submission that because the partition suit is filed, this 125 proceedings are filed. Yes. Now that's why we look at the court's order, how this aspect is dealt with. Yes.
The order was to start its effect from page 50. Reasons. Should I read that portion or not to the extent? The petitioners have filed this petition in section 1. The respondent seeking maintenance in other case of the outside is not in dispute that the petition is the one in the mother and the party respondent. Therefore, there is no dispute with regard to the relationship of the party to the parent of the respondent. That they have no means to negate the respondent also having sufficient means and negate to maintain them as the respondent one is not interested at the end of it. The respondent who is contained that the petitioner not having high income from various liability. Further secondary that the petitioners and respondent 1 to 3 are in joint possession of ancestral property. It is pertinent to note that the respondent of 2 and 3 have alleged themselves. We have petitioners and respondent of 1 are in joint possession and enjoyment of the family property. Can we say petitioner? It can be said that the petitioner has no secretary. The respondents have not produced any documents to show that the petitioners are drawing notification from government. It is the condition of respondents.
Please come to paragraph number 12. Paragraph 12.
And then,
yes.
The respondent being children, it is their voting to take care and maintain the age. The respondent documenting the obligation to undertake that their family is getting income of 12 lakhs from crops. So it is clear the respondents are having first, it is the family of father who is getting it and have pleaded for mean profits, which means not that mean profits have not been granted to you or allotted to my share. That is why it's
Come to your objections. Let's see this statement. What did you say? Where are your objections?
Page 35.
Yes. That is the suit. I'm asking you objections to this 125 CRP.
I take the addiction is I take the logic where
the Yes. Where did you say that?
This if the petitioners are having high income from rate of building, also from garden land of other city village. The respondent of the 2 is under the 182 and respondent of the 2 is joined to the following properties. The respondent summons the petitioner 1 and in service. The respondent of 1 is the part of the respondent. The petitioner 1 is part of the respondent. Respondent 1 is the other of the all the proposals and about properties and system joint family property. The petitioner for 1 is respondent for 1.
No, what exactly is this statement? That's what the court has.
The petitioner number 1 and respondent number 1. Other are the managers of the family. You are to find that correct.
I got filed this petition to deny legitimate share of the respondent, whatever the binding on the legitimate respondent. I, along with the respondents, got improved. I, along with the respondent, I'm looking at page 37, paragraph number 9.
And
we'll just complete this and go there.
Yes, yes.
Between the I, along with respondent, got improved the land, head so and so, and out of the joint efforts, the family of the petitioner and the respondent getting 12 lakh per year. That is according to her. She is also there. She is also getting. Yes.
That is why I wanted the Russian to just review the previous
Page 30. Hmm.
Where I made clause.
Hmm.
Please respond to issue number one is the father of this respondent and respondent number one is the author of this. In order to pass the aforesaid family property and joint family property. The petitioner number one and respondent number one are managers of the family. This is their they are managing the property. And the parties who the petition are due to issue members and the properties are concerned with joint family and they getting access to property purchase of the same process which could go on. You cut off the value of 4 years, the revenue becomes a standing. But the entire assets are being managed by the one and incidentally by the
But it is, she has.
I have stated that I am a joint family member. I am the owner of the property and entitled to equal rights in the state.
I'm reading from your objections. I'm not reading from. Please tell me what is the meaning of this. I, along with the respondent, got improved the land and out of the joint efforts, the family of the petitioner and the respondent getting 12 lakh per year. Please read.
Petitioner number one along with the respondent got into the land and once Petitioner number one along with the respondent starts. The petitioner number one along with the respondent got into the land and once That is where the logic It is the petitioner number one. Father, along with the respondent got into the land and once and out of the joint papers petitioner and respondent getting 12 lakh from
Which paragraph you said that I have nothing and I'm not in a position to pay the maintenance?
So my group okay. Para 11 must is para 12. With that, if they come, I will maintain. This is what I have stated on. These respondents are with that. These respondents are ready. These are the institutions are ready to handle. Also, please maintain the respondents also.
What is this? These respondent submits that the respondents are ready to, let me read it, to look after the petitioner if the petitions are ready to hand over all the suit properties.
And the next page,
No, why she's always referring to petitioner and respondent number one are having high means of income.
Father and son stay together. Father and son stay together.
Where do you get that? Let us see the address.
The address is at page 25. Father, mother, son. Petitioners and respondent number one. They stay in the same house.
You are appearing on behalf of whom?
I appeal for the daughters, respondent.
Both the daughters?
They are married.
2 and 3.
Yes, they are separate. They are plaintiffs in the suit for partition against the petitioners and respondent.
Come to the impugned order again, page number.
Notice, it's 43. It starts at 50.
You are paying 4,000. 6 plus 6 is 12. You are 3 in number. So you will be paying 4,000.
And married, you can understand it in the city.
What is the properties worth? Where is the suit? Where is the suit document?
Schedule and meeting.
Where is the valuation you spoke about? Where is it mentioned? Hmm?
Your Lordship asked us about the revenue what we had. That is in the statement of obligation. 37.
37?
37.
Hmm.
Where we have stated that petitioner and respondent owner, it is respondent owner, petitioner and respondent getting 12 lakh per year from Arakine, Chile.
Land, property worth, that's what you want the partition.
The valuations. These
Please
are
come.
all very interior property.
Please come. Agree with the.
Just look at the schedule for a moment.
Hmm.
Item number 2 is agricultural.
Hmm.
Situated here. Policy means not in the I mean not in the not even the house of interior. In general, the other one is
No, for one of the, no, for one daughter, 4,000. No, for per annum, 48,000. 48,000. What is the age of the parents? And you can pay the court fees. No, you can pay the court fees, you can file the suit, you can engage. You are not in joint possession of the property. Well, you say that it is in possession of them.
because we are in joint position, we are now looking into it, there are no mean profit, that is why I'm not the place of mean profits in partnership. But if I could just take one thing, but if your lordship was to say that, mean profit be granted, out of the mean profit, not I immediately. Because there is some amount of.
Can this court say in this criminal miscellaneous proceedings?
Just one thought. Because I can put on affidavit what is my income. Let the other side put their income on affidavit plus then the lordship.
It should have been done long back.
Because the trial court must then we not take that evaluation. If that evaluation is taken up to us, I think the truth will come. After that, lordship question, every query will be answered.
Don't ask for the property.
That can be taken care of.
Not necessarily, I'll record all the contention.
My only request to do is I file the affidavit of what is my income. Lordship may take note of that and ask it. I file the affidavit of what should be the income of these two daughters.
No, when you filed objections to this, are you not supposed to say, where is that specific government in the petition?
Unfortunately, I was not able to.
It is not there.
Absolutely right.
It's not there.
I taken the affidavit.
Why will we do it? Why should, we are only questioning we are only looking at the order that is passed by the court. No further.
Only one thing, it is guided to us, even if it could be 125 for a moment, even if it could be 125 for a moment. But does 125 empower a male or something what you might have to get?
Empower a?
Does it empower a male not to seek maintenance? Because here we are guided under the Adoptions and Maintenance Act being used. Now, not just a separate rules under the Adoption and Maintenance Act. Now, but whether 125 must be taken over is something.
Was it your objection, let's say?
That is not there. In fact, because these are statutory principles to us. It's a question of for this purpose under this act is a question which you not should have to consider because CRPC for COVID 125 not should have to look at it. Now what is 125 permits for such an inquiry. It's not, it is for the purpose not where if any person having sufficient means neglects or refuses to maintain vide, then was deep for a moment not. His father was unable to maintain himself or herself. The magistrate first time it starts with this not. Father mother unable to maintain himself or herself. Magistrate may, upon proof of such neglect or refusal, order such to make.
No, you said so in your objection saying that you accepted, you are not taking care. You said you come to my house, I will take care with all the properties.
My share will given, that's all I.
That I'll record, that I'll.
But that is not, for one moment, that is not exact. But insofar as clause B is concerned, for
Yes.
one moment, not.
Yes.
If you not, 125 was the only for one moment.
Yes.
It only speaks of this clause. Father or mother unable to maintain himself or herself. And that is true. Kindly see not. The previous other three clauses does not require proof. It's a moral obligation. If the lordship could just compare A, B, C for one moment, if the lordship could just see not. If the wife is unable to maintain herself, there is no question of proof here. The lordship could just see here.
Yes.
His legitimate or illegitimate minor child, whether married or not, unable to maintain it, then what? His legitimate or illegitimate child, not being a married daughter who has attained majority, where such child is by reason of any physical or mental abnormality or injury, unable to maintain it. There, in all these three clauses, not there's no question of proof. This fourth clause not with